that application.
This week, Your Ladyship. Any date this week.
When there is already an order fixed.
There's an order which says the report of Nazir is also received in the writ of delivery of possession. Nazir has reported that on 5/12/2025, date has been fixed for delivery of possession. On the spot, we have reached and started measuring the disputed property with the help of either commissioner.
This is which, this is the date.
This is in the execution case, Your Ladyship.
What is the date of that?
6/12/2025, Saturday. Ladyship, it has been said that
You see, when there is already a date fixed by a judicial order, you have to file an interlocutory application for postponing the date, otherwise it can't be taken up. There is a judicial order for fixing the date. So now, move back to the petition.
From date this case for finance to item 5, first appeal 175 of 2024.
Additional evidence. Again, number 14011
You have filed a reply?
Yes.
What do you say to this sign? What is your response to this sign?
I have already filed, ma'am, written out. IA.
What is your reply?
पिछले डेट में मैम बोली थी मैंने रिप्लाई दे दिया, फाइल कर दिया.
तो हम क्या बताएं? आपका क्या स्टैंड है?
मैं एडमिट कर रहा हूँ, वो डॉक्यूमेंट है. मैं बोली थी कि एडमिट करना है कि नहीं, मैं एडमिटेड है, मैं लिखित में भी दे रिटर्न में दे दिया.
एक बार जरा सा para 7 देखिए as of the response. So I may be permitted to place it. Page 4. Page 4 of the response filed by the respondents.
Yes.
Para 7 में they have stated in respect of my prayer, the prayer to adduce additional evidence is strongly opposed. Though it is candidly accepted, admitted that the lease deed alleged with the interlocutory application is genuine and has been executed by the parties and the term of the deed is acceptable or agreeable. The document sought to be introduced, lease dated 21/3/2025, came into existence after the passing of the interim judgment and decree dated 28/6/2024. It is a settled principle of law that the rights of the parties are crystallized on the date of institution of the suit. A document created subsequent to the dismissal of the suit cannot retroactively alter the nature of the property that was placed in the year 2003. However, they are in the affidavit they are opposing the my prayer for additional evidence. This is what I want from you.
Argue your case. We'll look at it later. There is no corresponding, if there is a subsequent event, post at any stage, then that has to be accompanied by an amendment. There is no amendment, corresponding amendment. You have just filed this additional evidence. So we'll take care of that. You argue your case.
Well, the plaintiff is the applicant before your lordship.
And there was a previous lease deed also of the same nature?
Yes, same.
Exhibit 3.
And just, what was the suit?
Partition.
How is this lease deed related to partition suit?
Madam, this lease deed has been entered by and between the plaintiff number 2 and the defendant number 2. They both are sister-in-laws, as in
Plaintiff number 2 and?
defendant number 2. Srimati Sonia Kakkar is plaintiff number 2 and Srimati Binny Kakkar is defendant number 2. They both Binny, B-I-N-N-Y, Binny Kakkar. So they have entered into this lease registered lease deed document with ICICI Bank to lease out their share of the property,
Both of them have entered
both
jointly.
jointly through the same document for the same piece of land and the building.
Lease with ICICI.
ICICI.
ICICI is a party.
No. It was instituted for partition. The property in question, which is defined at Schedule A of the plaint, has been acquired by plaintiff number 2 and defendant number 2 by virtue of registered sale deeds of the year 2003, particularly 20th of December 2003 and 30th of December 2003. If I can give the
Why 2 dates?
no, because there are two sale deeds.
And the sale deed relates to the entire suit property.
Both the sale deeds relate to the entire.
They cover the entire suit property.
Entire. That is 24 decimals. Now, the property under consideration now, the Schedule A property in respect of Sonia Thakkar, the registered sale deed is 6557, dated 2012-2003.
6557 dated
2012-2003.
03.
In respect of Khata number 84, plot number
Schedule
7217.
A. Schedule A.
Part of Schedule A. Schedule A includes two properties, two set of documents. Madam.
Schedule A is, this is first part.
This is first part.
Okay.
In the name of Sonia Thakkar. The second sale deed is area is 2.5 decimals. Madam. This is important.
Second. So far as first one is concerned, what is the area?
2.5 decimals.
2.5 decimal.
Decimals.
Second one,
Second one is sale deed number 373.
373 dated
30/12/2003.
area.
Madam, there are multiple plots. Total area is 21.5 decimals. This also includes Khata number 84, plot, same plot.
This is relating to whom?
This relates to Bini, defendant number.
There is no joint purchase.
No. The vendors are common, but it is not a joint purchase.
This one. The learned counsel for the applicant has submitted that plaintiff number 2, namely Sonia, and dependent number 2, namely B, they purchased property mentioned in Schedule A to the plaintiff. Plaintiff number 2 purchased 2.5 decimal of suit land, while registered sale deed number 6557 dated 2012-2003. And defendant number 2 purchased 21.5 decimal of land, while registered sale deed dated number 373 dated 30/12/2003 from the same vendor. From the same vendor. He has also submitted that both plaintiff number 2 and defendant number 2 have jointly leased out the entire Schedule A property.
My lord, the construction on the Schedule A property is, it is not on the entire schedule A. I mean, half of the portion is constructed. Building is constructed only upon the half of the portion.
Only building has been leased out or the entire area has been leased
So much. Building, even out of the portion of the building, certain portion has been leased out to the tune of initially 2414 square
out?
feet.
A portion of the building constructed over Schedule A property has been leased out to a bank, namely ICICI Bank. The lease deed was exhibited
Ma'am,
before the learned trial court as
exhibit number 3,
Exhibit 3, which is dated
11/8/2016.
11/8/2016 for a period of
9 years.
9 years, and it has been registered by deed number must be a registered deed.
Yes.
Okay. By registered deed.
3839.
Registered deed number 3839 dated 11/8/2016.
2016.
The period of lease has expired on
After 9 years, that is 10th of August. Right to this.
10/8/2025. 10/8/2025. Now the lease deed has been renewed,
Mine.
and the renewed lease deed is again for a period of 9 years.
9 years.
9 years, which is sought to be brought on record by filing interrogatory application number 1404
Bulb.
14011 of 2025, seeking to reduce additional fees. Yes.
The case of the plaintiff is that both the properties have been acquired from the source of income of the father-in-law, being late Kamal Kakkar.
You are the plaintiff, source of income. So there is a nucleus.
In the form of Spark Scooters, that is a business firm.
The source of income is, what is the source of income?
Spark Scooters is a business firm.
Spark Scooters. Okay.
Spark Scooters.
And who was the proprietor of this?
It was run by the father, and both the sons, being plaintiff number 1, Mr. Sanjay Kakkar, and defendant number 1, Mr. Vivek Kakkar.
Let us see the plate.
Para 1 is the description of the land. Para 2 is the details. Mary, madam?
Yes.
That father of the plaintiff number 1 and defendant number 1, and father-in-law of plaintiff number 2 and defendant number 2, namely Kamal Kumar Kakkar, used to do business in Bypass Road, Chars, in the name of Spark Scooter, in which plaintiff number 1 and defendant number 1 were also managing the business with their father and lived together from the joint fund of income of the business of the father of the plaintiff number 1 and defendant number 1. Decided that the land should be purchased from the income of business, on which both the brother agreed. Therefore, with the consent to each other, the father of plaintiff number 1 and defendant number 1 had purchased the land and area 2.5 decimals of Khata number 84, plot number 7217, in the name of plaintiff number 2, Sonia Kakkar, white seal deed number 6557, date 20/12/2003. And since the date of purchase, the plaintiffs and defendants, along with their parents, came in all act of possession over the said purchased land bounded as North Bypass Road, South owned house land of the said plot, East proposed rasta 12 feet wide, west building of Dubej. Thereafter again purchase of land of said khata number 84 plot 7217 area 7.25 decimals and lands of khata number 177 plot number 7208 area 10.75 decimals and same khata plot number 7208 area 3.5 decimals total an area of 21.5 decimals with specific boundary as north earlier purchased land, south plot number 7205, east proposed rasta 12 feet wide and west building of Dubeji from the rightful owners by way of registered sale deed number 375 dated 30/12/2003 in the name of defendant number 2. And since
No,
the
it's a benami practice.
my lord,
Because the daughter-in-law in a family and the son-in-law in a family, they do not form a co-partner. They are not co-partners.
they are
Then,
son-in-law and daughter.
what kind of partition are you seeking?
My lord,
You are seeking partition of this property. So what is there in your case? Nothing.
my lord, the property has been purchased from the nucleus.
Maybe.
My lord,
You see, property having been purchased from a nucleus in the name of one of the co-partners of the property. So, but when it comes to daughter-in-law and when it comes to son-in-law, they do not form a part of co-partner in any manner. So therefore, it cannot be subject matter of partition. What is the judgment? In which line? I have not read the
my
judgment. I
lord,
just
the
want to know.
judgment says that there is no unity and jointness of the title.
Certainly.
And
Correct.
since both are acquired, both the piece of lands have been acquired separately by way of separate sale deeds in the name of a particular person, so that cannot form part of the joint family property and therefore no partition will be allowed.
Even let's assume that the property came from this the money came from this business. Then also, it's penalty, not permissible under law.
So, but that aspect has not been dealt in the.
We will leave it. It's first appeal, no? You respond to this question.
That is true, madam.
It's clear cut penalty. There is no unity of title, there is no unity of possession, nothing. And it has not, this is absolutely meaningless. That the property was purchased from the joint family nucleus, they do not form. You see, they are not co-partners in the family. So any property purchased in the name of daughter-in-law or any property purchased in the name of son-in-law, I don't think that any nucleus has any relevance.
Madam, but exhibit 3, they both have entered together.
And how does that make a difference?
Madam, that makes
Both may jointly enter into some kind of lease agreement with a third party. And the lease agreement will be binding on all the three parties.
very respectfully, madam, in that case, only 2.5 decimals of land belongs to Sonia as per the registered sale.
Yes.
And the remaining 90% of the land, that is around 21.5 decimals, belong to defendant number 2. Now, if my lord looks into the exhibit 3, my lord will find that the proceeds of rent is being equally divided. On the
Makes no difference. You are seeking a partition suit. Then
What I want to establish that the properties are joint in the sense that despite having only 10% of the landed area,
it's too far-fetched.
but having only 10% of
Merely
the
because there could be a situation that the person is not taking any rent at all. Only one person is. Let's take the extreme situation. That in the lease deed only one person is taking the rent. So do you want to say that the entire property is to be divided equally? Merely because there could be a situation that no rent is being paid. Let's assume for a moment, right? One person gives another person a lease deed. No rent is being paid. He will only pay the stamp duty for the registration. That's it.
But both are parties to that lease deed.
It makes no
And
difference.
my lord, there is a very categorical, institutional payout in the sense that 50%.
It makes no difference.
Why I put a question to myself.
Post facto conduct does not confer title.
My lord, it is pre-institution of
No,
the suit.
post facto conduct. It means that after the sale deed is already executed,
My
your conduct post facto will not change the nature of the sale deed.
lord, the properties are admittedly purchased and acquired by way of two separate sale deeds. My lord.
That's it.
I am not denying the fact.
That's the end of it.
But the conduct of the parties has to be looked into when it's a matter
No,
of
that will
partition.
not change the nature of the sale deed. You should have asked for cancellation of sale deed or modification. We do not know what relief you could have
My
got.
lord, I understand.
But as long as the sale deed is existing, we can't go beyond that.
Sir, both are the registered documents. My lord,
तो
lease deed is also
घर का
registered.
पंचायत मत बनाइए लॉ पे बहस है.
My lord, therefore I am saying that the
It's not
conduct of the parties are
Not
very
at all.
clear. That 50% of the proceeds of the rent would be taken by one party and 50%
It
would
makes
be
no difference. Show me one law, one provision of law or any judgment that merely because the rent is being distributed 50-50 or merely because it is a conduct post facto, right? There could be a situation that you buy a property and hand it over to your brother. Simply hand it over to him. He becomes a title owner of that property. Does he become the owner of that property? By any means.
My lord,
So-
not necessarily, but in this case, not necessarily, what is correct on that, but not necessarily. In this case, what has happened, my lord? I have only 2.5 decimals of land through registered sale deed. Why? I put a question to myself. Why a person, an adversary in the litigation, would permit me to take 50% out of that? I have a reason to it, madam. The exhibit 3 was executed during the lifetime of the father-in-law, who has
So-
acquired in my humble submission.
He has acquired a Benami property. You just forget about that.
My lord, what I wanted to indicate that yes, the scope is very narrow in this case. What I wanted to indicate that there are certain perversity in the impugned judgment
So we'll come to the
in,
judgment
in
later.
respect of
We
exhibit
are,
3 itself.
we are on the plane right now.
My lord.
But prima facie and let's see what further story have you made out in the plane.
In para 4, my lord, of the plain, there is a categorical
You
statement.
just read para 3 also.
Para 2. That it is worth to mention here that before the purchase of the land, the vendor of the said sale deed executed an agreement in favor of plaintiff number 1 on 9/7/2003. And at the time of agreement, the plaintiff number 1 paid the entire consideration amount to the vendors of the sale deed by way of bank draft and other mode. Thereafter, the sale deed was executed in favor of plaintiff number 2 and defendant number 2. The said amount was paid by the plaintiff number 1 with the consent of his father from the joint fund of the income of the business of Spark Scooter and other. Therefore, the said property is the joint property of the parties, and they have been coming in possession of the suit land jointly, according to their convenience, however, without partition by metes and bounds. That just after purchasing this land, the father of plaintiff number 1 constructed 3-storied houses on the purchased land. The suit land, some part of the suit land from the income from the business and rest land is vacant and used by both the parties. That after construction of the building by the parties, they let out second floor of the building to Messrs. Hotel Casablanca on monthly rent, and other building was let out to one Sri Ram Finance, ICICI Bank, etc. And as per mutual consent, they obtained the rent of the said building to their convenience. Not only that, municipal tax and other taxes relating to suit land are also being paid by the plaintiff. That the suit property is joint property of the parties, and they have been coming in possession over the same according to their convenience, which was purchased by the father of plaintiff number 1 and defendant number 1 and father-in-law of plaintiff number 2 and defendant number 2. And as such, there is complete unity of title, comity of interest and unity of possession between the parties over the suit. That sometime in the year 2017, the father of plaintiff number 1 and defendant number 1, namely Kamal Kumar Kakkar, died in the state of jointness, and after his death, the plaintiffs and defendants inherited and succeeded over the entire suit property according to their convenience, which is in the knowledge of the entire locality, including the defendants. That sometime in the month of February 2022, both parties decided to amicably partition of the suit land. Therefore, memorandum of partition was prepared according to their convenience. But later on, the defendants flatly refused to make partition of the suit properties and thereafter they claim the suit land area 21.5 decimals by saying that the said land is purchased by defendant number 2. Thereafter, with greedy view to grab the rent as well as the suit property, a legal notice was sent by defendant number 1 to the tenant of the plaintiff, namely Sriram Fanas, through his lawyer on 30/6/2022. When after knowing about the said notice, the plaintiff became surprised because it was joint property of both and both have equal right. Thus, seeing their claim, Panchayati was also held between both the parties sometime in the second week of the month of July 2022, and in the said Panchayati, the defendant number 1 agreed to make partition of the suit land, but after lapse of 2 months, the defendants could not get it partitioned, and lastly, on 30/9/2022, flatly refused to make partition of the suit properties by meets and bounds. Hence, the plaintiff compelled to file the necessity of the suit. That the defendants have got no right to claim over the land or house on area of 21.50 decimals because the entire property has been purchased by father or father-in-law of both the properties, namely Kamal Kumar Kakkar, from income earned from the business of his path scooter. They have got every right of half share over the suit properties. That it is worth to mention here that the suit property is joint property of
Yes,
the
we have seen. The main meetings are already over. Rest is just ornament. What is the written statement?
written. In written statement, particularly in respect of my averment that the same has been purchased from the funds of the Spark scooter manner may take into consideration para 15 and 16, para 16
Read
and
from para 8.
that so far the contention made in para 1 of the claim, which is part and parcel of the present suit property having total area of 24 decimals, in which plaintiffs claim their partition. In this regard, the answering defendant submits that the property in which plaintiffs claim is not a joint property, and the property has not been purchased by joint income of the plaintiffs and the defendants have purchased the suit premises from their own hard-earned income. So no question arises for partition of the said premise. But in the evidence,
We come to the evidence later.
that so far the contention made in para 2 of the plaint is concerned, the answering defendant submits that the total contention is false, fabricated, false accusations let down in the para 2 of the plaint. The answering defendant submits that the plaintiff claim for partition of the said properties is not a joint purchase property from the income of both the parties. Rather, the true fact is that the scheduled properties have been purchased by the answering defendant from their own income. In this manner, the claim over the said properties is liable to be dismissed in the said terms and conditions set. It is submitted that there is no iota of evidence to substantiate the facts, so the entire contention made in the claim is totally false, hypothetical, and the plaintiff has to be proved with substantial evidence. That so far the contentions made in para 3 of the claim is concerned, the answering defendants submit that the entire contention made in the claim is totally false, hypothetical, and imaginary. It is submitted that the entire contention regarding payment of the consideration amount is totally false, hypothetical, and the plaintiff has not filed any document regarding the payment of any consideration amount to the vendors of the sale by way of demand. That so far contention made in para 4 of the plaint is concerned, the answering defendant emphatically denied the contention of the answering defendants.
Basically, the nucleus and joint purchase is different.
They say that there was Spark scooters at para 16. They say there is an existence of Spark scooters. Para 16.
Yes, it is not in dispute that there was a business.
And in the evidence, they say that we don't know what is a Spark scooters.
How does that make a difference? You have to make out your own case, no?
Absolutely true, madam. But this is not a title suit, madam. It is only for the purpose of partition. So, what my claim is that the property has been acquired rightly or wrongly through Spark Scooters Fund, and thereafter in their WS they say yes, there was a Spark Scooter, yes, we were partners, and from the income of the partner we have acquired this piece of land from our share. And in their oral evidence they turn around and say that I don't know anything about Spark Scooter. ये मेरे ट्यूशन से जो अर्निंग हुआ है, मैंने उससे इसको खरीदा है, और बिल्डिंग सिर्फ मेरे लैंड पे बना हुआ है और मेरा बनाया हुआ है, then how and why plaintiff number 2 was permitted to enter into it and get a half and half share from the proceeds of the rent? At the time when the property was acquired, she was only 20 years of age. As per the affidavit,
File in the with the
witness.
Which paragraph are you referring to? Of the
W
written
is
statement?
para 16 and 17. That so far contention made in para 9 of the plaintiff is concerned, the answering defendant submits that the entire contention made in the plaint are totally bogus, unethical approach of the plaintiff. As a matter of fact, the entire properties have been purchased by the answering defendant from his own income. It is submitted that the plaintiff mentioned in the plaint that Spark Scooters is a partnership firm, and being partners income, the answering defendant purchased the suit premises, and this manner the plaintiff has no right title interest over the suit properties. Further manner that submitting that so far the contention made in para 10 of the plaintiff is concerned, the answering defendant submits that the entire contention made in the plaint is out hypothetical, imaginary, and just to allay out false claims, the plaintiff brought this suit before the learned court, and the properties has not been purchased in joint fund, and the income of business of Spark Scooter, and being a partnership firm, all the partners have equal share, has been distributed from the income of this business. So no question arises for that the properties is a joint properties from the income of business of Spark Scooter. Just only to lay out the false claim over the suit properties, and just only to harass the answering defendants to lodge the partition suit, but there is no scope to file caption suit against the answering defendant. Now the defendant, witness number 1, who is also defendant himself, in his evidence says that Spark Scooter firm हम लोग का नहीं था.
फर्स्ट अपील में एविडेंस इतना सिलेक्टिवली नहीं पढ़ाया. पहले आप बताइए आपके डॉक्यूमेंट्री एविडेंस का.
मतलब three documents were exhibited. One is sale deed of Mrs. Sonia Thakkar.
Exhibit.
Exhibit number 1.
This is
Sale deed
sale deed of
6557.
Plaintiff 2.
Plaintiff
number 2.
Plaintiff number.
Number 2. Then exhibit 2.
Exhibit 2 is the sale deed of defendant number 2.
Defendant number 2. And exhibit 3 is the lease deed.
Is the lease deed with ICICI.
There is no evidence as to how the money was paid.
No, there is certain documents marked as X for verification. They were the receipts of the DD, which was made to be prepared at the time of payment of the land to be purchased. They were all marked as X. They were marked as X.
DD prepared by whom?
The DD was prepared by the plaintiff.
From by the?
By the plaintiff.
So where do we? What is the evidence? There must be some debit entry in the bank account.
That is true, but
Where is
bank
that?
account statement has not been received. Bank account statement has not been.
DD, from the face of the DD, you can't make out as to who has got it prepared. So it's of no relevance.
That is true, ma'am. The bank statement is not.
So source of fund, what is the source of fund? From where do you get this? On the so-called admission? What is the evidence?
Evidence in respect of the source of fund from the bank account of Spark Scooters is not available. That is true, my lord. I will not waste judicial time on that. That is not true. My only contention is in the respect that the Spark Scooters business was being carried out by the father.
What was the income of what was the range of income of Spark Scooter?
All were the income tax assessing.
What do you mean
But
income taxes?
documents are not. Only
The,
three
the
exhibits are there,
income,
madam.
the source of income is absolutely not available.
There are only three exhibits.
So,
Admittedly, there are no more exhibits. Only three exhibits. That is 2 sale leads and 1 lease deed. So these three documents are there, and their oral evidences are there, and which
how many oral evidences are there for the plaintiff?
there are 3 oral evidences.
Who all have been examined?
Plaintiff number 1 is PW3, madam.
PW3 is plaintiff number 1.
PW1 is one Ramakant Prasad. He was old manager of their business. PW2 is Mihir Kumar Singh.
Old manager of the firm.
Business, the firm.
PW2 is
PW2 is Mihir Kumar Singh. Again, he is also a staff member.
okay. What about the dependents?
There
How
are
many
only
witnesses?
two. That is dependent number 1 himself and dependent number 2 herself. And no
Dependent
doc-
number 1 is DW1.
PW1.
Dependent number 2 is DW2.
No,
No
exhibits.
The learned counsel for the appealant has submitted that the two properties were purchased by plaintiff number 2 and dependent number 2 respectively. And the source of fund was income from the firm namely Spark Scooters, which was the business, which was a partnership business in which the father of defendant number 1, the father of plaintiff number 1, who was the father-in-law of defendant number 1, father-in-law of defendant number 2.
Plaintiff number 1 is the son, plaintiff number 2 is the wife. Defendant number 1 is the son, defendant number 2 is the wife.
Son-in-law है ना?
Son.
They are full
Plaintiff-
brothers.
Yeah.
Plaintiff number 1 and defendant number 1 are full brothers.
4 brothers.
Yes.
In which the plaintiff number 1, dependent number 1 and their father, namely Kamal Kumar Kakkar, were the partners. He has submitted that altogether 3 witnesses have been examined on behalf of the plaintiffs. PW3 is the plaintiff number 1 himself. PW1 is Ramakant Prasad, PW who is the old manager of the firm, and PW2 is Mihir Kumar Singh, a staff in the aforesaid firm. Why plaintiff number 2 has not been examined?
She was not.
However, the plaintiff number 2 was not examined. who is the owner of a portion of the suit property by virtue of registered sale deed in a favor. So far as defendants are concerned, only two witnesses were examined. DW1, defendant number 1 was examined as DW1 and defendant number 2 was examined as DW2. And there is no exhibit and no document was exhibited on their behalf. Merely because in a firm there is father and 2 sons as partners, does it become a joint family business?
Not necessarily.
Not necessarily.
Not necessarily. But in this case, our
Partnership deed has been exhibited.
no, only 3 documents are there. 2 sale deeds and 1 this lease deed. That's all.
Let us see the evidence. Where is the oral evidence?
Madam, PW1, Ramakan Prasad, 20 of experience. पैरा 4 नंबर ही says यहाँ कि मैं इस फर्म एवं होटल कासाब्लांका में
PW1 is Ramakant Prasad.
बराबर ठीक है
ठीक है.
ठीक है PW पैरा 4 is मैडम PW1 यह कि मैं इस फर्म एवं होटल कासाब्लांका में करीब 33-34 वर्षों से मैनेजर के रूप में काम कर रहा हूँ यह कि उप विवादी जमीन जो दलील संख्या
ये होटल कासाब्लांका मैनेजर.
हाँ दोनों एक्चुअली कासाब्लांका एंड इस्पात स्कूटर्स दोनों यही लोग चला रहे हैं
नहीं ऐसा तो कुछ आपका प्लेंट में नहीं है.
प्लेन में नहीं बट दिस इज नॉट डिनाइड
No, from who will deny it? If it is not there in the plaint, who will deny it? Because he says that he is a manager of hotel Casablanca.
नहीं मैं इस फर्म एवं कासाब्लांका मैं इस फर्म
एक सेकंड पढ़िए ऊपर से पढ़िए. मैं रमाकांत प्रसाद
पेशा होटल कासाब्लांका मैनेजर साकिन होटल कासाब्लांका आईसीआईसीआई बैंक के सामने 400 मैं इस वाद में दोनों पक्ष को जानता हूं यह कि मैं इस वाद के विवादी भूमि एवं व्यावसायिक मकान को भी जानता हूं जो बाईपास रोड चास थाना चास बोकारो के अंतर्गत अवस्थित है यह कि अर्जी के तफसील वर्णित संपत्ति जो खाता नंबर 84 प्लॉट नंबर 7217 रकबा 9.75 डेसिमल्स एवं खाता नंबर 177 प्लॉट नंबर 72 एवं रकबा 10.75 डेसिमल्स प्लॉट नंबर 7209 रकबा 3.05 डेसिमल्स कुल रकबा 24 डेसिमल है जिसका बंटवारे के लिए ये बात चल रहा है यह कि मैं इस फर्म एवं
This
कासाब्लांका
firm means is referring to which firm? ऊपर कौन सा फर्म?
होटल कासाब्लांका मैनेजर, he says he is manager of hotel
So
Casablanca.
is firm means what?
That is
What is it referring to?
मैं इस फर्म एवं कासाब्लांका में,
Is firm मतलब?
but what conclusion I drew is he is
Because there is no
referring to
reference of Ispat
Ispat
Scooter in his previous statements.
there is no reference.
Then
There is no reference. Paragraph 5 of the plaint,
plain से नहीं चलेगा ना evidence.
हाँ, इसमें नहीं लिखा है इसने,
नहीं
and
लिखा।
ऊपर भी उसने यही लिखा है कि मैं मैनेजर हूँ कासाब्लांका. But what conclusion I drew for my sake of my submission, madam, for sake of my submission only, madam, that is firm is meaning thereby Ispat Scooters.
Show me something from it to make a submission.
The entire case is revolving around the funds of Ispat Scooter and the funds out of Ispat.
देखिए ये जो है ना ये एविडेंस एडवोकेट के साथ बैठ के बनाया जाता है, ठीक है? तो इसमें कोई इनोसेंस का कोई स्कोप नहीं है बोलने का. He is innocent and he does not know. There is no scope.
I will not argue that he is innocent and he does not know. Whatever is written, it is there.
Yes.
Whatever is there.
There is no reference of the
Yes,
form.
yes. Whatever is there is there. Then in paragraph 5, my lord, after referring to the plot details, he says,
Just read. The learned counsel for the appellant has referred to the evidence of PW1, who is Ramakant Prasad. And aged 51 years. And claims to be the manager of Hotel Casablanca situated in Chas, Bokaro. He has then referred to paragraph 4, wherein he has stated that this witness is the manager of inverted comma this firm and Hotel Casablanca, and submits that the term this firm in paragraph 4 of the evidence is referring to the firm mentioned in the plaint, that is Ispat Scooter. However, in the previous statement, there is no reference to the firm Ispat Scooter. Yes, read it, please.
paragraph 5, I'm skipping the plot details here. The relevant is मिनी कक्कड़ पति विवेक कक्कड़ के नाम से, जो दोनों के ससुर कन्वर कुमार कक्कड़ के सहमति से इस्पात स्कूटर के फंड से खरीदा गया है एवं खरीदने के बाद व्यवसायिक भवन निर्माण कर संयुक्त रूप से दोनों भाई संजय कक्कड़ एवं विवेक कक्कड़ एवं पिता संयुक्त रूप से व्यवसाय करते थे एवं किराया में घर को देकर संयुक्त रूप से किराया वसूल भी करते आ रहे हैं एवं अपने अपनी जीविका चला रहे हैं तथा खाली जमीन पर संयुक्त रूप से दखल भी करते आ रहे हैं। यह कि वर्ष 2004 बिन्नी कक्कड़ एवं सोनिया कक्कड़ दोनों मिलकर आईसीआईसीआई बैंक को लीज में दिया, जिसका वर्ष 2016 में पुनः रिन्यूअल कर अवधि को बढ़ाया गया, जो वर्ष 24-25 तक है, जिस पर बैंक एवं अन्य किराएदार अपना अपना व्यवसाय चला रहे हैं। यह कि वर्ष 2022 मई महीना में दोनों पक्षों में आपसी बराबर बंटवारा के लिए बंटननामा पत्र तैयार हुआ, परंतु प्रतिवादी संख्या 2 ने अपना दलील के आधार पर 21.5 दावा करने लगा एवं जून 22, 2022 में प्रतिवादी संख्या 2 ने श्रीराम फाइनेंस को वकालतन नोटिस भेजा। उस पर जुलाई माह में पंचायती हुई, उस पर प्रतिवादी बंटवारा के लिए सहमति बनाई, परंतु सितंबर 2022 में तैयार किया हुआ बंटवारा पत्र में हस्ताक्षर करने से इनकार कर दिया। तब वादी द्वारा यह बात न्यायालय के समक्ष दायर किया गया, यह कि वादीगण का दावा सही है एवं प्रतिवादीगण का दावा गलत है।
He has referred to paragraph 5 of his evidence to submit that. The two said it's were in the name of, were purchased with the consent of the father-in-law of plaintiff number 2 and defendant number 2. And the source of fund was Ispat Scooter. It has been also stated by this witness that after purchase of the property, plaintiff number 1, defendant number 1 and their father have been jointly running their business by constructing a building on the property. And have been realizing rent by letting out the house,
It's a commercial.
by letting out other portion of the building. And are running their livelihood. And so far as the vacant land is concerned, it is in their joint possession. He has also stated that in the year 2004, there was a lease agreement with ICICI Bank, which was to expire in the year 2016. And upon renewal, the lease deed is valid till the year 24-25. Cross for it. Yeah, just a moment. These are values.
Just a small correction in my argument, madam. PW2 is friend. Is 20-year-old friend of.
Yeah, Mr. Yes, Mister. Why don't you correct the cost item?
इसका वकालतनामा में पावा है वो आप उसी को
जो भी है, आप लोग आर्ग्यूमेंट करते हैं और आपको 10 बार फोन करते हैं हम लोग. Is it fair? You have no responsibility. The person who argues the case, he has a responsibility to get it done. Right? How many times has he called you? ऐसा नहीं करने का. नहीं तो हम बोल देंगे जिसका वकालतनामा नहीं रहेगा वो नहीं रहेगा, तो हम किसी को बहस नहीं करने देंगे. फिर आप बोलिएगा कोर्ट ऐसे बोलते हैं. जिसका वकालतनामा है उसको साथ में रहना चाहिए ना बहस करते समय. Then, and then we have to run after you. You get it done. Yes, that was his friend.
Yes, ma'am. That is. I apologize, my lord. I said he was a staff member.
I will check it, don't worry about it. You see, these are the dictations prima facie for my memory. And then when I will finalize the order, I will check it and then put it accordingly. There is no problem.
DP hours.
Yes.
Para 9 of the cross-examination of
So
the.
you did the entire process.
Not exactly, that starts with para 9. The cross starts with para 9.
Yes.
मेरा गांव
Please,
सुकर
please hold. Nice.
प्रति कलेक्शन साक्षी संख्या नंबर 1 रमाकांत प्रसाद। मेरा गांव सुकर हरी डी हरी पोस्ट हकुराई परसिया थाना नरसिंहगंज जिला रोहतास बिहार है। मैं वर्तमान पता रामनगर कॉलोनी 4 बोकारो है। मैं रामनगर कॉलोनी में 20 वर्षों से रह रहा हूँ। मैं संजय कक्कड़ जी के यहाँ 35-36 वर्षों से नौकरी कर रहा हूँ। वर्तमान में भी यही काम कर रहा हूँ। प्लेंटिफ नंबर 1 संजय कक्कड़। मेरा उम्र 51 वर्ष है। मैं जिस केस में गवाही देने आया हूँ उस केस का नंबर मालूम नहीं है। मुझे आज गवाही देने के लिए संजय कक्कड़ जी ने कहा है, इसलिए मैं आज गवाही दे रहा हूँ। संजय कक्कड़ का एक घर वाला जमीन है और एक होटल वाला जमीन है। घर वाला जमीन का रकबा नहीं जानते हैं, लेकिन होटल वाला जमीन 2.5 डेसिमल जमीन है। संजय कक्कड़ घर वाला जमीन लता दत्त से खरीदे हैं। कब खरीदे हैं इसकी जानकारी मुझे नहीं। मैं जब काम कर रहा था उसी दौरान घर वाले जमीन खरीदा गया था। इसका खाता नंबर और प्लॉट नंबर नहीं बता सकते। मेरा घर वाला जमीन का दस्तावेज नहीं देखे हैं। मैं संजय कक्कड़ जी का मैनेजर हूँ। मुझे मासिक 8,000 रुपये मिलता है। इस वाद पत्र में क्या लिखा हुआ है मुझे जानकारी नहीं है। संजय कक्कड़ जी के होटल वाला जमीन किस मौजा में आता है मुझे मालूम नहीं है। उपरोक्त जमीन का होटल वाला जमीन दस्तावेज नहीं देखा हूँ। शपथ पत्र में क्या लिखा हुआ है इसकी मुझे जानकारी नहीं है। जमीन खरीदने के लिए संजय कक्कड़ ने पैसा दिया था। कितना पैसा जमीन वाले को दिया था इसकी जानकारी मुझे नहीं है। पैसे का लेन देन मेरे सामने कभी नहीं हुआ था। मुझे जानकारी नहीं कि जमीन का दस्तावेज घर वाला और होटल वाला किसके नाम पर खरीदा गया है। संजय कक्कड़ जमीन खरीदने के लिए कहां से पैसा दिए थे ये मुझे जानकारी नहीं है। होटल वाला जमीन का खाता नंबर 84 प्लॉट नंबर 7217 है। घर वाला जमीन का खाता नंबर और प्लॉट नंबर नहीं बता सकते हैं। ऐसी बात नहीं है कि मैं संजय कक्कड़ के यहाँ काम करता हूँ इसलिए झूठी गवाही देने आज आया हूँ।
कोई जानकारी नहीं। He is rather absolutely hostile to the case. He has said that he does not know from where the money has come. Nothing. He has not supported your case in any manner. Correct? आगे बढ़िए।
PW2 मिहिर कुमार सिंह, पिता जन्मेजय सिंह, आधार नंबर 1600, डिटेल 1600। मैं इस वाद में दोनों पक्ष को जानता हूँ। यह कि इस वाद में विवादी भूमि एवं मकान को भी जानता हूँ जो 4 थाना अंतर्गत मौजा 4 जिला बोकारो के अंतर्गत अवस्थित है। खाता नंबर 1600, प्लॉट नंबर 1600। यह कि इन दोनों के पिताजी कमल कुमार कक्कड़ इस्पात स्कूटर का मालिक था एवं कक्कड़ परिवार से मेरा दोस्ती यारी 20 वर्ष पहले से चला आ रहा है। दोनों का संयुक्त जमीन जायदाद एवं व्यवसायिक संबंध में मुझे पूर्व से जानकारी है एवं परिवार को भली भांति से जानते हैं। यह कि जब से विवादी जमीन संयुक्त पूंजी में जमीन का खरीद की गई उस समय संजय कक्कड़ के माध्यम से जमीन का सारा रकम का लेन देन हुआ। तब से लेकर वर्तमान तक संयुक्त रूप से दखल कब्जा देखते आ रहे हैं तथा विवादी जमीन पर बना हुआ मकान, दुकान, होटल है उसका किरायानामा कागजात भी संयुक्त रूप से बनाकर किराए में दिया गया है एवं दोनों मिलकर संयुक्त रूप से किराया वसूल भी करते आ रहे हैं। यह कि बिन्नी कक्कड़ के नाम से दलील संख्या 100 बना हुआ है जिसमें अधिक जमीन लिखा हुआ है एवं अगल बगल के लोग के उस काव में प्रलोभन दिखा दिया एवं भाई भाई में आपस बराबर बंटवारा नहीं करना चाहता है एवं वादी बराबर बंटवारा चाहते हैं, इसलिए वादी द्वारा यह वाद लाया गया है। यह कि वादीगण का दावा सही है एवं
You
प्रतिवादी
see, this witness has said that the business belonged to their father. He has not stated that there was a partnership formed and there were partners. It is not there. Right? So he has not supported the claims so far as this aspect is concerned. It is one thing to say that the business belongs to the father and he gave money and the property was purchased. It is another thing to say that there was a partnership formed between three and they used to run the business and how the property was purchased. Your case is of a partnership firm, not of a proprietorship firm of father.
In
What is
fact,
the cross-examination?
not even in the cross he has supported me.
Let's
यह बात सही है कि मेरे सामने कभी भी किसी प्रकार का कोई लेन देन नहीं हुआ है। इस्पात स्कूटर का मैं कभी भी कोई दस्तावेज नहीं देखा हूँ, इसलिए यह नहीं बता सकता हूँ कि इस्पात स्कूटर के मालिक कौन कौन हैं या पार्टनर कौन कौन है। मुझे इस बात की जानकारी नहीं है कि दोनों पक्षों में से कहां से रुपया लेकर जमीन खरीदी थी। यह बात सही है कि दोनों पक्षों का अपना जमीन का अलग अलग अपने नाम का दस्तावेज दलील है। मैं किराए का कोई भी किसी प्रकार का दस्तावेज नहीं देखा हूँ। एक पक्ष सोनिया कक्कड़ के नाम से 2.5 डेसिमल जमीन है तथा दूसरे पक्ष बिन्नी कक्कड़ के नाम से 21.5 डेसिमल जमीन है।
This also witness does not support you. Who else?
The plaintiff number 1 himself, PW3. It's the longest one. मैं संजय कक्कड़, पिता स्वर्गीय कमल कुमार कक्कड़, सुवंशु पैरा 1। मैं इस वाद के वादी संख्या 1 हूँ एवं यह वाद मैंने प्रतिवादीगण के विरुद्ध संयुक्त संपत्ति का बंटवारा हेतु लाया हूँ। यह कि प्रतिवादी संख्या 1 मेरे सगे भाई हैं तथा प्रतिवादी संख्या 2 मेरी भाई की पत्नी है। यह कि इस वाद में वर्णित तफसील संपत्ति जमीन को जानता हूं, जो मौजा चास थाना चास के अंतर्गत बाईपास रोड चास में अवस्थित है, जिसका सर्वे खाता संख्या 84 प्लॉट 7217 एवं खाता संख्या 177 प्लॉट 7208 एवं 7209 से संबंधित है। यह कि तफसील वर्णित संपत्ति प्लॉट संख्या 7217 रकबा 2.5 डेसिमल खाता 84 वादी संख्या 2 सोनिया कक्कड़ के नाम से रजिस्टर्ड दलील संख्या 6557 दिनांक 20/12/2003 को खरीदा गया एवं दलील संख्या 373 दिनांक 30/12/2003 के द्वारा प्रतिवादी संख्या 2 बिन्नी कक्कड़ के नाम से प्लॉट संख्या 7217 रकबा 7.25 डेसिमल्स एवं प्लॉट संख्या 7208 रकबा 10.75 डेसिमल्स तथा प्लॉट संख्या 7209 रकबा 3.50 डेसिमल्स कुल 21.50 होना चाहिए खरीदा गया। उक्त दोनों दलील का जमीन इस्पात स्कूटर फर्म के संयुक्त आय से खरीदा गया है। यह कि उक्त जमीन की खरीद बिक्री में जमीन दाता के साथ वादी संख्या 1 ने इकरारनामा आदि कराकर जमीन मूल्य का लेन देन नकद रुपए का अलावा संजय कक्कड़ ने कैनरा बैंक खाता 10063 में किया गया। यह कि वादी संख्या 1 के द्वारा कैनरा बैंक खाता संख्या 10063 में जमा राशि की रिसीट दिनांक 8/12/2003 की 3 प्रति है, जो जेरॉक्स कॉपी है, जिसे क्रमांश so these were marked as X for verification. 8/12/2003, 10/12/3, 13/12/3, 15/12/3 और 19/12/3 का है, जिसका रकम जमीन मालिक मनोज कुमार साहू को दिया, जो डिमांड ड्राफ्ट का विवरण निम्न प्रकार है। कैनरा बैंक डिमांड ड्राफ्ट नंबर 555113 dated so and so X and similarly number X by 1 2 3 4 5 6 7 on the next page para 6. These are the receipts of the demand draft. Money receipt दिनांक 20 para 7 यह कि रजिस्टर्ड दलील संख्या 6553 दिनांक 20/12/2003 का सच्ची प्रति है, जो सोनिया कक्कड़ के नाम से निबंधित है, जिसे प्रदर्श 1 अंकित किया जाए एवं रजिस्टर्ड दलील संख्या 373 दिनांक 30/12/3 की सच्ची प्रति है, जो बिन्नी कक्कड़ के नाम से निबंधित है, जिसे प्रदर्श 2 अंकित किया जाए। यह कि उक्त जमीन खरीदने के बाद प्लॉट संख्या 7217 पर दलील संख्या 6557 का 2.5 डेसिमल दलील संख्या 373 के रकबा 9.34 डेसिमल्स 9.75 डेसिमल्स दोनों के पिता एवं वादी संख्या 2 तथा प्रतिवादी संख्या 2 के ससुर के सहमति से संयुक्त रूप से 3 मंजिला पक्का मकान बनाकर होटल कासाब्लांका एवं श्रीराम फाइनेंस आईसीआईसीआई बैंक आदि को संयुक्त रूप से किराया पर लीज के तहत दिया गया एवं संयुक्त रूप से किराया वसूल करके उसका बंटवारा करते आ रहे हैं, जिसका लीज डीड नंबर 3839 दिनांक 11/8/16 है, जिसकी सच्ची प्रति न्यायालय में दाखिल किया हूं, जो बिन्नी कक्कड़ एवं सोनिया कक्कड़ द्वारा आईसीआईसीआई बैंक को लीज पर दिया गया, जिसे प्रदर्श 3 अंकित किया जाए। यह कि दोनों रजिस्टर्ड दलील सो एंड सो का मूल मालगुजारी रसीद संख्या 5300 डेटेड 2015 एवं शुद्धि पत्र जो राजस्व कर्मचारी के हस्ताक्षर के द्वारा निर्गत किया गया है, दिस वाज नॉट मार्क्ड एज एन एग्जिबिट, प्रदर्श अंकित नहीं किया। यह कि
2012 में और 25 कब का?
2003 2015 का है, एक रसीद है हमारे
2000 ये जो तथा 2012 का एक पार्टनरशिप डीड निर्गत
हाँ
क्या है?
मतलब ये पार्टनरशिप हुआ
मार्क
था
नहीं हुआ है, बट इट्स अ पार्ट ऑफ योर एविडेंस। ये पार्टनरशिप 2012 में
नहीं, मतलब ये पार्टनरशिप इट इज इन रिस्पेक्ट ऑफ
ऐसा कोई पार्टनरशिप फॉर्म था, ऐसा भी अप्रूव नहीं कर पा रहे, वो भी नहीं आ रहा है। डीड को क्यों नहीं एग्जिबिट कर रहा है?
नहीं
So therefore there is no evidence that there was a partnership form.
my pleading is there only,
क्या evidence?
no documentary evidence. पैरा 11 करोड़ यह कि जब प्रतिवादी संख्या 1 के द्वारा श्रीराम फाइनेंस को वकालत नोटिस दिनांक 30/22 को दिया, तब वह नोटिस देखकर वादी संख्या 1 आश्चर्यचकित हो गए, जिसे लेकर जुलाई माह 2022 को एक पंचायती हुई। तब पंच के समक्ष प्रतिवादी संख्या 1 बंटवारा के लिए राजी हुए एवं बंटननामा का प्रारूप तैयार हुआ, परंतु उक्त बंटननामा पर प्रतिवादीगण अपना अपना हस्ताक्षर करने से दिनांक 30/9/22 को इनकार कर दिया। तब बराबर हिस्से का प्राप्त करने के लिए यह बंटवारा वादीगण द्वारा न्यायालय में प्रतिवादीगण के विरुद्ध दायर किया गया है, जो संयुक्त पूंजी से विवादित जमीन खरीदा गया है, जो सोनिया कक्कड़ एवं बिनी कक्कड़ के नाम से निबंधित दलील गया है, जो खरीदने के बाद से ही संयुक्त रूप से बिना किसी बाधा विघ्न के शांतिपूर्वक के दखल कब्जा करते आ रहे हैं एवं वर्तमान में भी उक्त संपत्ति इजमाइल संयुक्त है, जो बराबर हिस्सा में बंटवारा योग्य है। यह कि वादीगण का दावा सत्य है, प्रतिवादीगण का दावा गलत है। पैरा 13 क्रॉस मैं होटल का व्यवसाय करता हूँ। मैं 2 भाई और 2 बहन हैं, जिसका नाम है अलका।
ये स्कूटर भी चलाते हैं, स्कूटर वाला फॉर्म के बारे में नहीं बोल रहे हैं, होटल का व्यवसाय करते हैं।
ये होटल का व्यवसाय अभी कर रहे हैं, मतलब प्रीवियसली ड्यूरिंग द लाइफ टाइम ऑफ द फादर ही वो
ये कैसे? ये तो आपका पार्टनरशिप फॉर्म, पार्टनरशिप का कहानी नहीं एस्टैब्लिश हुआ।
नहीं, पार्टनरशिप का सिर्फ एक स्टेटमेंट है, डॉक्यूमेंट ये नहीं है, आई मीन एग्जिबिटेड नहीं है।
कंट्रोल के बाहर है चीजें। एनीवेज आगे बढ़िए।
मैं होटल का व्यवसाय करता हूँ। मैं 2 भाई हूँ, 2 बहन हूँ, जिसका नाम अलका महेंद्र, संजय कक्कड़, विवेक कक्कड़ और ऋतु मल्लिक है। चारों लोग शादीशुदा हैं। हम सभी चारों भाई और बहन अलग अलग रहते हैं और अपना अपना व्यवसाय करते हैं। बोकारो। एक
सेकंड, मैं 2 भाई और 2 बहन।
हाँ,
बहनों को पार्टी नहीं है, उनको पार्टीशन नहीं होना चाहिए भाई। जब आप जॉइंट फैमिली प्रॉपर्टी बोल रहे हैं तो बहनों को कैसे आउट करते हैं? The entire family is not before the court.
they are not parties. हम सभी चारों भाई बहन अलग अलग रहते हैं और अपना अपना व्यवसाय करते हैं
अपना अपना व्यवसाय करते हैं।
at the time of deposition.
We do not know.
I
भाई
think
अपना
specified नहीं
अपना
है, specified
भाई
नहीं है।
आपका जो एविडेंस में आ रहा है वो यही है ना, कहाँ लिखा है कि किस तारीख से करते हैं, कहाँ लिखते हैं कि at that point of time there was a joint family business, कुछ नहीं।
It's a weak piece of oral evidence, my lord, I must admit.
आगे बढ़िए।
Further, he has not also supported the case.
चलिए
He
बढ़िए।
himself has not supported.
हाँ।
मैं I was reading paragraph 30.
जी हो गया, अपना अपना
16.
व्यवसाय करते हैं।
बोकारो में मैं और मेरा भाई विवेक कक्कड़ रहते हैं। दोनों भाई 20 वर्षों से अलग अलग रहते हैं और अपना अलग अलग व्यवसाय करते हैं। मैं और मेरी पत्नी सोनिया कक्कड़ आयकर दाता हैं तथा मैं और मेरी पत्नी अलग अलग व्यवसाय करते हैं। मेरे भाई विवेक कक्कड़ और उनकी पत्नी विनी कक्कड़ भी आयकर दाता है तथा दोनों विवेक कक्कड़ और विनी कक्कड़ अलग अलग व्यवसाय करते हैं। मैं, मेरी पत्नी सोनिया कक्कड़ एवं विवेक कक्कड़ एवं बिन्नी कक्कड़ लगभग 30-35 वर्ष से आयकर दाता है, आयकर देते आ रहे हैं। मैं मेरे पिताजी का निधन वर्ष 2017 में हुआ। इस्पात स्कूटर फर्म में हम लोग 3 पार्टनर थे जिनका नाम कमल कुमार कक्कड़, संजय कक्कड़ और विवेक कक्कड़ है। इस्पात स्कूटर फर्म में से तीनों पार्टनर को अलग अलग तनख्वाह वेतन मिलता था और तीनों व्यक्ति अपने अपने आमदनी का आयकर देते थे जो अपना अपना आयकर भरते थे। प्रदर्श 1 में दलील संख्या 100 एंड 100 वह सही है और जो मेरी पत्नी सोनिया कक्कड़ ने अपनी आमदनी से खरीदी है। पुनः कहते हैं कि अपने व्यवसाय के आमदनी से नहीं खरीदी। यह बात सत्य है कि मेरी पत्नी ने जो जमीन खरीदी थी जिसका केवाला संख्या 100 एंड 100 उसमें जो स्टाम्प ड्यूटी लगा था वह रुपया 100 एंड 100 मेरी पत्नी ने भुगतान किया था। यह बात सही है कि दलील संख्या इतना में जो सोनिया कक्कड़ के नाम से रजिस्टर्ड है इसमें जो लिखित रुपया 2,95,000 अंकित है वह डीडी नंबर 555182 दिनांक 19/12/2003 जो कैनरा बैंक से बना हुआ था, जो कंसिडरेशन अमाउंट था जो मेरी पत्नी द्वारा विक्रेता को दिया गया था। प्रदर्श 2 में वर्णित केवाला संख्या 373 दिनांक 30/12/3 बिन्नी कक्कड़ द्वारा जमीन मालिक से खरीदा गया था। यह बात सही है कि बिन्नी कक्कड़ ने जो केवाला संख्या 373 खरीदी थी उसका कंसिडरेशन अमाउंट 4,05,000 विक्रेता को दिया जिसका डीडी नंबर 555183 दिनांक 19/12/3 कैनरा बैंक से बनाकर दिया गया था जो केवाला दलील में वर्णित है। यह बात सही है कि बिन्नी कक्कड़ ने रुपया 1,37,000 का स्टैम्प ड्यूटी का भुगतान किया है जो दलील इतना में लिए गए भुगतान किया गया है। मेरी पत्नी और बिन्नी कक्कड़ ने जो जमीन खरीदी वह अपने अपने नाम से अलग अलग तिथियों में खरीदी है। यह बात सही है कि दोनों जमीन का शुद्धि प्रमाण पत्र म्यूटेशन अलग अलग नाम से है और मालगुजारी रसीद अलग अलग और अपने अपने नाम से करता है। पहचान हेतु अंकित X55 डीडी नंबर 100 एंड 100 डेटेड 19/12/2003 मेरी पत्नी सोनिया कक्कड़ ने अपने जमीन खरीदने के लिए जमीन मालिक मनोज कुमार साहू को ही दिया था जिसका केवाला दलील संख्या 100 एंड 100 है। कंसिडरेशन अमाउंट इस 100 एंड 100 के रूप में दर्ज है। पहचान के रूप में अंकित X/6 डीडी नंबर 555183 दिनांक 19/12/2003 रकम 100 एंड 100 प्रतिवादी संख्या 2 बिन्नी कक्कड़ ने अपनी जमीन खरीदने एवज में जमीन मालिक मनोज कुमार साहू को कंसिडरेशन मनी के रूप में दिया था जिसका जिक्र केवाला दलील इतना में भी किया गया है। यह बात सही है कि प्रदर्श संख्या 1 में दिया गया केवाला दलील संख्या 6557 दिनांक 20/12/3 मेरी पत्नी सोनिया कक्कड़ वादी संख्या 2 के नाम से जमीन खरीदा गया है। उक्त केवाला दलील में खाता नंबर 100 एंड 100 जो सोनिया कक्कड़ द्वारा जमीन मालिक मनोज कुमार साहू से खरीदा गया है। प्रदर्श 2 में अंकित केवाला दलील संख्या 373 दिनांक इतना बिन्नी कक्कड़ द्वारा जमीन मनोज कुमार साहू के से खरीदा गया है जिसका खाता नंबर 100 एंड 100 डिटेल्स इस देयर जिसका कुल रकबा 21.5 है। प्रदर्श 3 में दस्तावेज न्यायालय में प्रस्तुत किया गया है। उसमें आईसीआईसीआई बैंक द्वारा जांच पर्चा सह घोषणा प्रपत्र नियम 114 निबंधन विभाग झारखंड सरकार बोकारो का जो रेंट इकरारनामा दिया गया है, जिसमें खाता नंबर 84 प्लॉट नंबर 7217 जो सोनिया कक्कड़ के नाम से है, उस प्लॉट से कोई भी जमीन भाड़ा में आईसीआईसीआई बैंक द्वारा नहीं दिया गया है, बल्कि खाता नंबर 100 प्लॉट नंबर 100 जो बिन्नी कक्कड़ के नाम से है, जिसमें 2414 स्क्वायर फीट जमीन भाड़े के रूप में आईसीआईसीआई के बैंक द्वारा लिया गया है, जिसका जिक्र निबंधन विभाग झारखंड सरकार के बोकारो में जांच पर्चा सह घोषणा प्रपत्र के टोकन नंबर 112/816 में अंकित है। इस पे थोड़ा सा एक्सप्लेनेशन हम दे देंगे मानो डेटा पार्ट पैरा 36 की।
क्या कहना चाह रहे हैं आप इसमें?
इफ माइनॉट में सी एग्जिबिट 3 उसमें जो रूल 114 जो झारखंड रजिस्ट्रेशन रूल्स है, मतलब उसमें डिटेल्स ऑफ द प्लॉट देना होता है रजिस्ट्रेशन के टाइम पर या अगर लीज डीड हो रहा है तो उसमें दिस प्लॉट इज वेरी वेल रेफर्ड में 84 प्लॉट नंबर 7217। सो
It doesn't have much relevance.
मतलब इसमें क्योंकि
इसका कोई रेलेवेंस ही नहीं है। इसका लीज डीड में क्या प्रॉपर्टी लिखा है नहीं लिखा है, इसका बहुत ज्यादा कोई रेलेवेंस नहीं। We will, when the document is there, we will go by the document and not by the oral evidence.
सेक्शन 92 एविडेंस
It's a registered document.
यस
इसका कोई बहुत ज्यादा रेलेवेंस है। I am sure court might not have taken much serious objection to this.
My lord, the court has recorded this in the impugned judgment, and that I wanted to show the perversity is there. That the court says that there is no reference to khata number 84 plot number 7217 in the name of Sonia Kakkar in exhibit 3.
Okay, we'll see that.
Man.
We'll see that. But you just read it further.
हाँ, पैरा 37 प्रदर्श 3 में अंकित शेड्यूल में जमीन का विवरण है। खाता नंबर 84 प्लॉट नंबर 7217 7208 और 7209 है। इस उक्त खाता प्लॉट से आईसीआईसीआई बैंक का लीज पर लिया गया है। उपरोक्त खाता और प्लॉट का जमीन से लीज हुआ है जो शेड्यूल में वर्णित है, शेड्यूल टू द एग्जिबिट 3। यह बात सही है कि मेरे पिता का हस्ताक्षर किसी भी केवाला दलील में या न्यायालय में मेरे द्वारा प्रस्तुत किया गया किसी भी दस्तावेज में नहीं है। यह बात सही है कि प्रदर्श 3 में जो ई स्टैम्प लिया गया है वह बिन्नी कक्कड़ नाम से खरीदा गया है, जो 100 का है, जिसका प्रमाण पत्र नंबर 100। यह बात सही है कि किसी भी प्रकार का बंटवारा दस्तावेज नहीं बनाया गया। यह बात सही है कि जमीन का किसी भी प्रकार का साझेदारी का कोई दस्तावेज नहीं बनाया गया। ऐसी बात नहीं है कि मेरे द्वारा दावा गलत है। This is the evidence on behalf of the plaintiffs. There are two evidences on behalf of the defendant. DW1 is dependent
वो
on
डॉक्यूमेंट आप बताइए जो आप बता रहे थे।
my lord, exhibit 3 may be taken into consideration for a moment.
Exhibit 3.
Exhibit 3, the portion of the schedule. Schedule 1.
रिसाइटल में क्या है?
Recital portion में relevant is clause number 2, the consideration amount, and the effect that.
Description of property.
My lord, schedule 1, that is description only. If I may be
आपके पास इसकी
permitted.
कॉपी है?
I copy it. Again, it is ineligible kind of document, but I can read it.
This is the Eliza Miller. I asked him to read. It's so small in font.
It is after clause 12. Schedule 1 is after clause 12, 11, 12, 10, 11, 12 on the same page, along subsequent pages.
Let's see. Yes, read.
Schedule 1 description of the demised premises. Within district Bokaro, PS Chas, district sub-registry of Bokaro at Chas, Mauja Chas number 30, खाता number 84.
किस प्रॉपर्टी के लिए बोले हैं कि नहीं है इसमें?
हमारा तो सेकंड वाला विदिन डिस्ट्रिक्ट बोकारो PS चार्ज डिस्ट्रिक्ट सब रजिस्ट्री सो एंड सो, इससे क्लियर हो जाता है हमारा एरिया 2.5 डेसिमल।
ये आगे पढ़िए, पूरा पढ़िए इसको।
पहला वाला दूसरा वाला?
दोनों पढ़िए।
दोनों। खाता नंबर 84 प्लॉट नंबर 7217 एरिया 7.25 डेसिमल एंड सामिल खाता नंबर 177 प्लॉट नंबर 7208 एरिया 10.75 डेसिमल एंड प्लॉट नंबर 7209 एरिया 3.5 डेसिमल, total area 21.5 decimals, bypass road Chas, Bokaro, Jharkhand, so and so. Within district Bokaro, PS Chas, district sub-registry of Bokaro at Chas, Mauja Chas number 30, खाता number 84, plot number 7217, area 2.5 decimal, bypass road Chas, Bokaro, Jharkhand. This is the land acquired by plaintiff number 2 through the sale deed, registered sale deed. The learned court, trial court says that this is not in the lease deed. ICICI Bank bypass road at measuring ground floor 2414 square feet. But my total landed area is only, so far registered sale deed is concerned, only 1000 and odd square feet. 2.5 decimals. Comes around 1000 something square feet. Thereafter, our owners, Mrs. Benny Kakkad, wife of Sri Vivek Kakkad, and Mrs. Sonia Kakkad, wife of Sri Sanjay Kakkad.
What about dependent evidence?
Well, प्रतिवादी नंबर 1 शपथ पत्र मुख्य परीक्षण गवाह संख्या 1 धारा 1। मैं इस वाद में प्रतिवादी संख्या 1 हूँ। मैं दोनों पक्षों को जानता एवं पहचानता हूँ। मैं इस वाद में वर्णित तथ्यों से भली भांति परिचित हूँ। इस वाद में वर्णित तफसील जमीन से मेरा कोई लेना देना नहीं है। यह जमीन जिस खाता नंबर 84 प्लॉट नंबर सो एंड सो प्लॉट खाता नंबर सो एंड सो प्लॉट नंबर सो एंड सो कुल रकबा 21.5 डेसिमल है जो मौजा चास में अवस्थित है। मैं प्रतिवादी संख्या 2 का है जो है प्रतिवादी संख्या 2 का है और उन्हीं के द्वारा अपनी कमाई से खरीदा गया है। यह जमीन वादी एवं प्रतिवादी का संयुक्त संपत्ति नहीं है। मुझे बेवजह का परेशान करने के लिए वादीगण द्वारा प्रतिवादी नंबर 1 बनाया गया है। ना तो मेरे नाम से उपरोक्त वर्णित तफसील संपत्ति है और ना ही मेरे पास कोई उक्त जमीन से संबंधित कागजात है। चूंकि यह जमीन प्रतिवादी संख्या 2 बिन्नी कक्कड़ का है, इसलिए मेरा उक्त जमीन से किसी प्रकार का कोई सरोकार नहीं है। उपरोक्त वर्णित तफसील का जमीन प्रतिवादी संख्या 2 बिन्नी कक्कड़ द्वारा अपने कमाई से दिनांक 30/12/2003 को जमीन मालिक विनोद साहू, प्रमोद कुमार साहू, कुमुद साहू, दिलीप कुमार साहू, असीम कुमार साहू, मनोज कुमार साहू से प्राप्त स्वयं एवं मुख्य ग्रहिता मनोज कुमार साहू से दलील संख्या 373 के तहत जमीन का सर्वोच्च मूल्य 4,05,000 रुपए डीडी संख्या 555183 दिनांक 19/12/2003 के माध्यम से जमीन मालिक मनोज कुमार साहू को भुगतान कर ली है। रजिस्ट्री के बाद से उक्त जमीन पर प्रतिवादी संख्या 2 बिन्नी कक्कड़ का दखल कब्जा है जो वर्तमान में भी है। उपरोक्त वर्णित तफसील जमीन प्रतिवादी संख्या 2 के द्वारा खरीदगी के उपरांत उक्त जमीन का मालगुजारी समेत सभी प्रकार का टैक्स कर झारखंड सरकार को दिया जाता है। उन्हीं के नाम से मालगुजारी रसीद एवं सभी प्रकार के जमीन से संबंधित कागजात हैं। मेरे अधिकतम जानकारी में प्रतिवादी संख्या 2 स्वतंत्र रूप से अपने व्यवसाय करती हैं और उसी कमाई से उपयुक्त जमीन अपने नाम से खरीदी है। सत्यापन मैरोड इन दी क्रॉस पैरासन शपथ पत्र पर मेरा हस्ताक्षर है। मेरे पिताजी का नाम स्वर्गीय कंवल कुमार कक्कड़ है। मेरे शपथ पत्र में मेरे पिता का नाम स्वर्गीय कमल कुमार कक्कड़ लिखा है, जो प्रिंटिंग गलती है। मेरा जन्म दिनांक 25/5/68 में हुआ है। मैं जिस केस वाद में गवाही दे रहा हूँ वह वाद संख्या 58/2022 है। यह वाद संजय कक्कड़ ने विवेक कक्कड़ और बिन्नी कक्कड़ पर किया है। वादी ने यह वाद किस लिए किया मुझे जानकारी नहीं है। इस वाद में अपने तरफ से मैंने कोई कागजात न्यायालय में दाखिल नहीं किया है। इस वाद में बिन्नी कक्कड़ अपने दावे हेतु कोई कागजात दाखिल की है या नहीं मुझे जानकारी नहीं है। बिन्नी कक्कड़ के नाम पर कौन कौन सा खतियान की संपत्ति है मुझे जानकारी नहीं है। बिन्नी कक्कड़ के जमीन से मेरा कोई लेना देना नहीं है। फर्दर मानो दिनांक 11/2/22 को कच्चा बंटन नामा सोनिया कक्कड़ एवं बिन्नी कक्कड़ के बीच बनाया था, इसका मुझे कोई जानकारी नहीं है। ऐसा कोई बंटन नामा नहीं बना था, इसलिए दोनों का अपना अपना जमीन है। मुझे इस बात की जानकारी नहीं है कि मेरा कोई होटल नहीं है। इस वादी एवं प्रतिवादी दोनों के संबंध में कोई होटल है कि नहीं मुझे इस बात की जानकारी नहीं है। प्रश्न, होटल का नाम कासाब्लांका है, विवादित जमीन पर है। उत्तर, कासाब्लांका होटल कौन कौन से पर इस 21 कासाब्लांका होटल कौन कौन प्लॉट पर बना हुआ है मुझे जानकारी नहीं है। 22 इस्पात स्कूटर फर्म हम लोग का नहीं था। Whereas in the pleading portion of the WS in paragraph 16 and 17 he says कि फर्म था और पार्टनर्स थे और उससे जो अपना अपना शेयर्स का अपना अपना फंड्स जिसका है उससे हम लोग ने अपनी अपनी प्रॉपर्टी खरीदी। यहाँ पैरा 22 में ही से इस्पात स्कूटर फर्म हम लोग का नहीं था। यह बात सही नहीं है कि ICICI बैंक को लीज दलील संख्या सो एंड सो दिनांक 11/8/16 को बिन्नी कक्कड़ और सोनिया कक्कड़ दोनों मिलकर खाता 84 प्लॉट सो एंड सो रकबा सो एंड सो एवं खाता नंबर स्किपिंग दिस प्लॉट पोर्शन में दिनांक सोनिया कक्कड़ के नाम पर है तथा उपरोक्त खाता प्लॉट एवं रकबा 21.5 जो दलील संख्या इतना 30/12/2003 जो बिन्नी कक्कड़ के नाम है। यह बात सही नहीं है कि दिनांक 18/2/12 एक पार्टनरशिप डीड बना था जिसमें संजय कक्कड़, सोनिया कक्कड़, विवेक कक्कड़ पक्षकार था। यह बात सही है कि जिस केस नंबर 289/2022 हमारा धारा 144 का चला, हम चारों के बीच चला था, लेकिन 144 नहीं लगा था बल्कि स्टेटस को का आदेश हुआ था। ऐसी बात नहीं है कि दिनांक 11/2/22 को सोनिया कक्कड़ बिन्नी कक्कड़ के बीच एक बंटन नामा कच्चा बना था। मैं दिनांक 30/6/22 को मेरे द्वारा श्रीराम फाइनेंस के अपने अधिवक्ता वकालत नोटिस भेजे थे। उक्त नोटिस को मैंने कोर्ट में दाखिल नहीं किया है। He claims that he does not know anything about the land and then he issues notice to the tenant that you evicted. जुलाई 2022 को पंचायती नहीं हुआ था। ऐसी बात नहीं है कि दिनांक 30/9/22 को बंटवारा के लिए अंतिम बार मुकर गए। प्रश्न, आप विवादित बिल्डिंग से जितने दुकान है अपने आप भाड़ा लेते हैं? उत्तर, मैं मालिक नहीं हूं। उस पर बिल्डिंग का मालकिन बिन्नी कक्कड़ है। उस पूरे बिल्डिंग का मालकिन बिन्नी कक्कड़ है। इस्पात स्कूटर फर्म का मालिक कोई नहीं था। सोनिया कक्कड़ एवं बिन्नी कक्कड़ के नाम जो दलील बना है उसमें मैं किसी दलीलों में गवाह नहीं हूं। ऐसी बात नहीं है कि मैं जानबूझ करके सही बात को छुपाकर झूठी गवाही दे रहा हूं। देन डिफेंडेंट नंबर 2 DW2, मैं इस वाद में प्रतिवादी संख्या 1 मैं दोनों पक्षों को जानती एवं पहचानती हूँ। मैं इस वाद में वर्णित तथ्यों से भली भांति परिचित हूँ। इस वाद में वर्णित तफसील जमीन मेरी गाढ़ी कमाई के पैसे से मेरे द्वारा खरीदा गया है। यह जमीन जिस खाता नंबर 84 प्लॉट नंबर 7217 और खाता नंबर 177 प्लॉट नंबर 7208 7209 कुल रकबा 21.5 डेसिमल जो मौजा चास अवस्थित है, जिसे मैंने रैयत से 24/1/2004 को रजिस्ट्री करवाई थी, जिसका सभी कागजात मेरे पास मौजूद है जो मेरे नाम से है। मुझे बेवजह का परेशान करने के लिए वादीगण द्वारा प्रतिवादी नंबर 2 बनाया गया है। मेरे वादीगण से किसी प्रकार का कोई लेना देना है। मैं अपने पैसे से जमीन खरीदी हूँ और सोनिया कक्कड़ अपने पैसे से जमीन खरीदी है। दोनों का अपने अपने जमीन पर दखल कब्जा है और काबिज है। एक दूसरे के जमीन से किसी प्रकार का कोई लेना देना नहीं है। वादीगण बेवजह मुझे परेशान करने की नीयत से यह मुकदमा मेरे विरुद्ध लाया गया है। सोनिया कक्कड़ और हमारा अपना अपना स्वतंत्र अस्तित्व है और एक दूसरे से हम लोग का कोई लेना देना नहीं है। दोनों का अपना अपना अलग व्यवसाय है। उपरोक्त वर्णित तफसील का जमीन अपने कमाई से दिनांक 30/12/2003 को जमीन मालिक विनोद प्रसाद साहू, प्रमोद साहू सो एंड सो से दलील संख्या नंबर 373 के तहत जमीन का सर्वोच्च मूल्य 4,05,000 रुपए डीडी नंबर सो एंड सो डेटेड 19/12/2003 के माध्यम से जमीन मालिक मनोज कुमार साहू को भुगतान कर दी। रजिस्ट्री के बाद से उक्त जमीन पर पूरा दखल कब्जा है, जो वर्तमान में भी जिस पर मैं अपना व्यवसाय करती हूँ। उपरोक्त तफसील जमीन खरीदगी के उपरांत उक्त जमीन का मालगुजारी समेत सभी प्रकार का टैक्स कर झारखंड सरकार को देती हूँ। उपरोक्त जमीन का मालगुजारी रसीद एवं सभी प्रकार का जमीन से संबंधित कागजात मेरे नाम से है। मैं अपना खुद का व्यवसाय करती हूँ और उसी कमाई से उपरोक्त जमीन अपने नाम से खरीदी है। मैं आयकर दाता हूँ। प्रतिपरीक्षण मैडम ने यह बात संजय कक्कड़ ने लाया, जो वह विवेक कक्कड़ विरुद्ध लाया। मुझे केस नंबर याद नहीं है, पुनः कहती हैं केस नंबर 58 और 22 है। मैं ट्यूशन करती हूँ, पुनः कहती हैं मैं व्यापार करती हूँ। मैं ट्यूशन करती हूँ और ऑनलाइन बिजनेस करती हूँ, अपने नाम से करती हूँ। मैं वर्ष 2018 से ऑनलाइन व्यवसाय करती हूँ। वर्ष 2018 से पूर्व मैं ट्यूशन का व्यवसाय करती थी। सोनिया कक्कड़ मेरी गोतनी लगती है, जो कि बड़ी है। मेरे नाम से जो डीड है उसका नंबर याद नहीं है। खाता नंबर 7217 7208 7209 जिस दिन दलील बना उस दिन दिसंबर 2003 में बना था। मैं जमीन मालिक को जमीन के एवज में 4,05,000 रुपए डीडी के माध्यम से दी हूँ, जो डीडी नंबर सो एंड सो है। जिस खाता से बना है वह मैं न्यायालय में दाखिल नहीं कर सकती हूँ। चूंकि वह बहुत पहले बंद हो चुका है। डीड नंबर सो एंड सो दिनांक 19/12/2003 का कॉपी मेरे द्वारा न्यायालय में दाखिल नहीं किया गया है। मेरे नाम से जो दलील है वह मेरे द्वारा न्यायालय में दाखिल किया गया है। सोनिया कक्कड़ के दलील के बारे में मुझे कोई जानकारी नहीं है। मुझे इस बात की जानकारी नहीं है कि सोनिया कक्कड़ के नाम से दलील 65 सो एंड सो प्लॉट नंबर 7217 रकबा 2.5 डेसिमल है। मेरी शादी 1991 में हुआ था। इस्पात स्कूटर फर्म के बारे में मुझे कोई भी जानकारी नहीं है। कासाब्लांका देखे होटल के बारे में मुझे कोई जानकारी नहीं है। श्रीराम फाइनेंस कंपनी कासाब्लांका के बिल्डिंग में चलता है, मुझे इस बात की जानकारी नहीं है। दिनांक 11/2/22 को मेरे और सोनिया कक्कड़ के बीच कोई बंटवारा नहीं बना। ऐसी बात नहीं है कि दोनों दलील में कुल रकबा लगभग 24 डेसिमल जो संयुक्त फंड से खरीदा गया है और वह जमीन अभी तक इजमाइन में है। विवेक कक्कड़ मेरा पति है। जिस समय मेरा शादी हुआ था उस समय मेरा पति कौन चीज का सप्लाई का व्यवसाय करता था मैं नहीं जानता हूँ। ऐसी बात नहीं है कि मेरे एवं सोनिया कक्कड़ के बीच में बंटन नामा बना था, जिसमें दिनांक 30/9/22 को मैं हस्ताक्षर करने से मुकर गया। कमल कुमार कक्कड़ मेरे ससुर जी थे। प्रश्न दलील संख्या 3839 जो आईसीआईसीआई बैंक पक्ष में बना गया है, इसमें बिन्नी कक्कड़ हस्ताक्षर है कि नहीं है? उत्तर उसमें मेरा हस्ताक्षर है। अपने हिस्से का जमीन का है और सोनिया कक्कड़ के जमीन का हिस्सा का है, लेकिन दोनों का हस्ताक्षर एक ही डीड पर है जो बैंक द्वारा बनाया गया है। मेरा जन्म तिथि 26 अक्टूबर 1970 है। मैं अपने जमीन का चौहद्दी जानती हूँ। उत्तर में सोनिया कक्कड़ का जमीन, दक्षिण में खाली जमीन है, पश्चिम में जगमोहन, पूरब में विकास पांडे का जमीन है। शादी से लेकर वर्ष 1996 तक संयुक्त रूप से खाना पीना बनता था। दलील बनाने खरीदने में मेरा पति पहल जमीन खरीदने में किया था। मेन रोड के बाद सोनिया कक्कड़ का प्लॉट है, उसके पीछे मेरा प्लॉट है। पूरा बिल्डिंग मेरे ही प्लॉट में बना हुआ है जो आईसीआईसीआई बैंक लीज में दिया गया है। मेरा जमीन संबंधित जो कागजात है वह डीड, म्यूटेशन, पंजी 2 और लगान रसीद और नापी वाला कागजात जो कि अंचल अधिकारी बोकारो द्वारा किया गया है। उपरोक्त कागजात मेरे इस संबंधित कार्यालय से बनाया गया है। उपरोक्त कागजात वर्ष 2023-24 का बनाया गया है। मैं अपने शपथ पत्र पर आज हस्ताक्षर की हूँ। शपथ पत्र पर लिखी सारी बातें वकील साहब मिलकर कल रात में लिखाया था। ऐसी बात नहीं है कि विवादित जमीन के बारे में मुझे कोई जानकारी नहीं है और आप दूसरे के कहने पे आकर झूठी गवाही दे रहे हैं एवं इजमाइल संपत्ति को बंटवारा करने से मुकर रहे हैं। The pleadings contained in the written statement and the oral evidences and Exhibit 3 all are inconsistent. Exhibit 3 is a registered document. The WS is a response to my claim, wherein there is a categorical admission on the fact that Spark scooter was there, partners were there, and they have their own share. And out of those share, the proceeds from those share, they have purchased the scooter. And in the oral evidence, both defendant number 1 and 2 turn around and says we don't know anything about this scooter. And ये मेरी गाढ़ी कमाई की है और ये मैंने खुद से इसको किया है, ट्यूशन पढ़ा के किया है। Then so far
In the written statement, they have not stated that it is the property purchased by self-acquired property.
so far self-acquired property there is one statement कि ये
There
जमीन
is a
खरीदी भी है,
statement.
but response to my claim categorically they have said कि प्लेंट में जो स्पार्क स्कूटर है वो बिजनेस फर्म था। हम लोग जो पार्टनर्स का जो भी डिवाइडेड शेयर था उससे अपने से लिया गया है। Therefore, the plaintiff do not have any right, title, interest or claim over the property of Binny Kakkar. This is their standing. And so far Exhibit 3 is concerned, Exhibit 3, the ICICI Bank is upon a building which is constructed over a piece of Schedule A land. That is in the entirety 24 decimals of land. Out of that 24 decimals of land, 21.5 decimal of land belongs to Binny Kakkar through registered sale, and 2.5 decimals of land belongs to Sonia Kakkar by the virtue of the registered sale. Now I put a question to myself: if at all a building is constructed, she DW2 defendant number 2 says that the entire building is constructed on her piece of plot. May be true, may not be true. Let us assume it is true. Then why she would permit a stranger to enter into the lease deed, a registered document, and accrue the rent and get the rent proceeds every month continuously right from 2007? That deed is again not exhibited, madam. I don't know why, but that deed is also not exhibited. 2007 में एक लीज डीड हुआ जो एक्सपायर किया 16 में, 16 वाला एक्सपायर किया 25 में, अभी वो अगेन उसमें एंटर किया जो 34 में एक्सपायर किया। So chain of lease deeds. Why a person would permit somebody else who does not have any relation to the land or to the building to enter into a lease agreement and have equal share of the proceeds for every month, and the proceeds in the subsequent document, which is under through by way of the IML, there is a clear stipulation that it is on the pro rata basis, proportionate to the ownership. My land, if registered deed is to be seen, sale deed, that is only to the tune of 2.5 decimals. that is around 10 point something percent of the land. So if at all there is a building and there is a lessee there, so that cannot go beyond 10%. Why anybody would permit? And why such a false and bold statement that the building is constructed only upon my piece of land? These are the issues, my lord, which has not been taken care of by the learned tribunal, in my respectful submission. If my lord may take the impugned judgment now. My lord, issues are framed. Para 2 and 3 are the stories, my lord. The plate and the response.
Yes.
My lord.
Yes, what are the issues which are framed by the
Para 4, I will take into consideration of the impugned judgment, my lord. Issue number 1 may I read? That is the internal page 10 of the judgment. 10 of 20. Para 4. 1. Whether the suit is maintainable in its present form. 2. Whether suit is properly valued. 3. Whether there is a valid cause of action to bring the present suit. 4. Whether the suit is barred by law of limitation, waiver, estoppel, and acquiescence. 5. Whether plaintiff is entitled for half share in the suit property. 6. Whether there is unity of title and possession amongst the parties to the instant scheduled property. Issue number 5 and 6 have been taken together, my lord, at page 12 of the impugned judgment.
Yes, sir.
Last portion at the bottom, findings. Para 7, issue number 5 and 6. Whether plaintiff is entitled for half share in the suit property, and on the subsequent page, madam, and whether there is unity of title and possession amongst the parties to the instant scheduled property. As both these issues are interrelated with other, hence it's taken together for discussion. Plaintiff and defendants, may I read the entire portion?
Yes, sir.
Plaintiff and defendants of this case are the members of the same family as per the plaint. The father of plaintiff number 1 and defendant number 1, and father-in-law of plaintiff number 2 and defendant number 2, namely Kamal Kumar Kakkar, used to do business in Bypass Road, Chas, in the name of Spark Scooter, in which plaintiff number 1 and defendant number 1 were also managing the business with their father and lived together from the joint fund of income of the business of the father of the plaintiff number 1 and defendant number 1. Purchased the land and area 2.5 decimals of Khata number 84, plot number 7217, in the name of plaintiff number 2, Sonia Kakkar, white sale deed number 6557, dated B-2012-2003, and since the date of purchase, the plaintiffs and defendant, along with their parents, came in all act of possession over the land. Thereafter, again, a land was purchased of Khata number 84, plot number 7217, area 7.25 decimals, and lands of Khata number 177, plot number 7208, area 10.75 decimals, and same Khata, plot number 7209, area 3.5 decimals. Total an area 21.5 decimals in the name of defendant number 2, white sale deed number 375, dated 30/12/2003, and since after the date of purchase, the plaintiffs and defendants came over the possession over the property. the sale deed which was executed in favor of plaintiff number 2 on 9/7/2003, and at the time of agreement, the plaintiff number 1 paid the entire consideration to the vendors of the sale deed by way of bank draft and other mode, and sale deed executed in favor of defendant number 2 with the consult of his father from the joint fund income of the business of his past scooters. After purchasing of the land, the father of plaintiff number 1 constructed 3-storied houses on the purchased land from the income of the business, and after the said construction, both the parties let out the second floor of building of Messrs. Hotel Casablanca on monthly rent, and other building was let out to one Shriram Finance, ICICI Bank. As per mutual consent, they obtained the rent of the said building according to their convenience. The father of both the parties died in the year 2017 in the state of jointness, and after his death, the plaintiff and defendant inherited and succeeded over the entire property. The defendants have submitted that the suit property is having a total area of 24 decimals, in which plaintiff claimed for their partition in this regard. The answering defendant submits that the properties in which plaintiffs are claiming is not joint property, and the property has not been purchased by joint income of the plaintiffs and defendants. As the defendants had purchased the suit property from their own income, so there is no question of partition of the property. The suit property has been purchased by their answering defendant by their own income. The plaintiffs have not filed a chit of paper with regard to construction of multi-storied building in this case. The defendant is a landlord and a bona fide purchaser of the said property, and the defendants constructed multi-storied building, and they let out the premises only through agreement to ICICI Shriram Finance Limited Bank. The said property was never purchased by power of the father of plaintiff number 1 and defendant number 1, so there is no question of unity and title. Now coming into oral evidences adduced by the plaintiff. PW1 Ramakant Prasad in his examination in chief, he has
So
said,
these we are already read.
My lord.
All the evidence we
My
are
lord.
read in full text.
Then the finding is there, my lord.
It's very good.
My lord, may take into consideration page 19 of the impugned judgment, my lord, the last paragraph.
Yes.
After discussing the evidences, documentary evidences and oral evidences,
It is evident.
it is evident from the oral as well as documentary evidence that Exhibit 1, which is a sale deed number 6567, was executed in the name of Sonia Kakkar, and regarding which Sonia Kakkar had made a payment of the consideration amount to the executant of the sale deed. Similarly, Exhibit 2, that is sale deed number 373, in the name of Binny Kakkar, wife of Vivek Kakkar, defendant number 2, and the consideration amount of the said sale deed of rupees 4,05,000 was paid through bank draft by Binny Kakkar. And this factum has been very well mentioned in Exhibit 2. It appears from Exhibit 1 and 2, which is two different plots adjacent to each other, and in the said plot of Binny Kakkar has been given on lease by Binny Kakkar and Sonia Kakkar to ICICI Bank, and the said lease deed has been marked as Exhibit 3. But as deposed by PW3, who happens to be plaintiff number 1, he has deposed that in Exhibit 3, which is a lease deed executed in favor of ICICI Bank, in which a declaration has been given that Khata number 84, plot number 7217 belongs to Sonia Kakkar, which has not been occupied by the ICICI Bank, but Khata number 177, plot number so and so, which belongs to Binny Kakkar, has been given on lease by the ICICI Bank. Even from the perusal of Exhibit 3, the description of scheduled property mentioned is Khata number 84, plot number 7217, area 7.5 decimals, and Khata number 177, plot 7208, area 10.75 decimals, and plot number 7209, area 3.5 decimals, total area 20.5 decimals. The owner of the said property is Binny Kakkar and Sonia Kakkar, as it appears from Exhibit 3 that only a lease has been given by way of Exhibit 3 to the ICICI Bank, but there is no joint ownership of the said property. Now, in my humble submission, while recording this finding that even from the perusal of Exhibit 3, the description of the scheduled property mentioned is Khata number 84, plot number 7217. So far, the land of Sonia Kakkar is concerned to the extent of 2.5 decimals, that has not been taken into consideration. There is no reference that Khata number 84, plot number 7217 also contains 2.5 decimals in the units, which is in the schedule of the said lease deed.
You just read it. But as deposed, exhibit 3
Ma'am,
is,
who happens to be plaintiff number 1, he has, this is in respect of para 36, ma'am.
that's right.
He has deposed that in exhibit 3, which is a lease deed executed in favor of ICICI Bank, in which a declaration has been given that khata number 84, plot number 7217 belongs to Sonia Kakkar, which has not been occupied by ICICI Bank, but khata number 177, plot number 7209, which belongs to Binny Kakkar, has been given on lease by ICICI. Even from perusal of exhibit 3, the description of scheduled property mentioned is khata number 84, plot 7217, area 7.5 decimals. And khata number 177, plot number 7208, area 10.75 decimals. And plot number 7209, area 3.5 decimals. In total, area 20.5 decimals. So the land in the name of plaintiff number 2 has not been recorded here. Then partition, next paragraph. Partition is a redistribution or adjustment of pre-existing right among co-owners oblique partners, resulting in division of lands or other properties jointly held by them. For partition of any property, there must be jointness of the said property, and the parties to the partition suit should have equal right and share over the said property. In a partition suit, the court is required to define the share of the parties. In a property which is a joint property, but in this case, the suit property mentioned in Schedule A of the plaint, corresponding to khata number 84, plot number 7217, khata number 177, plot number 7208, khata number 177, plot number 7209, area 24 decimals, are actually two different plots, which was purchased through sale deeds, which are marked as exhibit 1 and 2, respectively. And through exhibit 1, plaintiff number 2 purchased 2.5 decimals of land. Plaintiff has taken a plea that in the year 2022, a Bantan Nama was prepared between both the parties, and the said Bantan Nama has been filed before the court after closure of the evidence, which neither bears the date nor the name of the parties, along with their signature, which is not having any importance in the eye of law. And this Bantanama does not suggest any right over the partition between both the parties. The partition of any property can only be taken into consideration when the property is a joint property and purchased from joint family fund or acquired from the ancestors. Plaintiff in this case could not file any single chit of paper pertaining to the payment of consideration amount through joint income. Further, even the signature of father of the plaintiff number 1 and defendant number 1 is not there in both the series. Neither there is any contention with regard to payment from the joint income in the sale. The property mentioned, this is important, the property mentioned in Schedule A were purchased by plaintiff number 2 and defendant number 2 by their own source of income, and this is well mentioned in the sale deed. But as a matter of fact, this is not there. It is only, the sale deed only says that the money has been paid by her. The impugned judgment gives a categorical finding that this is well mentioned in the sale deed. I have perused the sale deed, my lord, I could not find this. Not only this, the plaintiff failed to prove that the property was purchased from the joint
Just
fund.
they say that this is well mentioned in schedule in exhibit 1 and 2.
1 and 2.
This is an error of record.
Yes.
This is what you want to say.
Yes. There is a reference to the payment by the vendor, but from their own source it is not referred there in the recital portion or in anywhere in the sale.
Need not be. There is no legal requirement to disclose the source of income in the sale.
But this is a wrong finding.
No, maybe it's a wrong finding, but there is no legal requirement to disclose the source of fund from in the same.
But
Can
in
come
a
from
suit
anywhere.
of partition, there is some requirement that you have to state the source of fund.
No, not
Otherwise,
in the
how-
sale deed.
Not in the sale deed, not in the sale deed, but the
See, you are throwing the onus on them to disclose their source of income, failing which you want us to assume that there is a joint family.
yes,
But
yes.
the very concept of joint family and very nucleus which is required in the joint family, the initial onus is that there is a joint family, there is a nucleus, and there is a sufficient nucleus to buy the property. Where is that evidence?
No, that is not.
In absence of that
There is no
evidence,
evidence.
in absence of that evidence, even if two brothers and their father are living jointly, they are joint in mess,
Yes.
right? Although it has come in the evidence that they separated sometimes, they were joint in mess only till 1996.
Right.
It has come in the evidence. Irrespective of that, even if they assume that they all were living together, where is that, even if there is a joint family, where is the nucleus? Nucleus means there has to be a source and coupled with the fact that it is a sufficient source. Both the aspects of the matter is required to be proved in order to claim partition. So the nucleus, the source, the availability of fund to buy the property, etc. is not there.
It is not.
And on top of this, there are 3 persons in a partnership. They are all filing their independent income tax returns, right? They are deriving income from the partnership firm. Then, under such circumstances, their income partakes the character of their individual income.
Self-required.
It becomes their self-acquired income because they are putting their effort in the business. Even if we assume, firstly, it is difficult to assume that these 2 ladies had no source of income, right? Secondly, even if we assume that these 2 persons, their husbands, had given them the money to purchase the property, then also it is difficult to assume that that particular fund was flowing from a joint family nucleus. Then how this partition can be allowed?
Only one document is in my humble submission is Exhibit 3. That demonstrates the conduct of the parties only. Because as per the written statement and as per the oral evidences, there is no
A person
coherence
may-
between the Exhibit 3.
A person may come to the court and speak lies, right? But that will not give a benefit to you. It is essentially your onus to prove that there was a joint family and there was a joint family nucleus and there was enough nucleus to buy the property. So,
But that,
आके कोई झूठ बोल दे तो आपको benefit थोड़ा हो जाएगा.
that is the initiation point, my lord. But the case is premised upon the fact that Exhibit 3, which is the lease deed, has been entered into the parties. My lord, I agree on the fact that the preliminary requirement has not been fulfilled. I agree on that, my lord. I'm
If
not-
that is not done, the matter ends.
My lord, Exhibit 3 is a registered document. It holds the genuineness in its favor, presumption of genuineness in its favor, my lord.
Exhibit 3 is saying what? That it's a
Exhibit-
joint family property.
Exhibit 3 is saying that the ICICI Bank would have an area, carpet area of 2414 square flats, and the proceeds of the rent would be equally 50-50 likha hua hai, 50-50 distributed between the.
You see, firstly, ICICI Bank is not having the entire
Correct.
property,
Correct.
correct? So we do not know what about the rest of the properties. If there are 2 plots, they are joined together and a building comes up, we do not know where the building is located. There is no evidence to that effect, that the building is located in plot belonging to plaintiff number 2 or in the plot belonging to plaintiff number, defendant number 2, right? But the fact remains that both the sale deeds are mentioned in Exhibit 3, right? It's a building which has come up in both the plots, correct? And even the vacant space forms a part of the tenancy. You can't say that the vacant space around the building does not form a part of the tenancy. There cannot be any tenancy of this nature, right? So both the building is coming up with that. In the building, there is a one portion of the property which has been let out. In letting out that portion of the property, it has been mentioned 50-50. We do not know what about the rest of the building, what is the arrangement between two. We cannot assume that for rest of the building also, there are perhaps numerous tenants on the building, right? We do not know what is the arrangement so far as the rest of the building is concerned. Two persons who have joined their asset to for the purposes of building. One can say that okay, for one floor you take the rent, for another floor I will take the rent. That is quite possible.
That is possible.
So therefore, merely because 50% is mentioned, this is not for the entire suit property. The tenant is not on the entire suit property. He is only in a portion of the suit property. Then merely because 50% has been mentioned, how do we assume that they admit that they had 50-50 rights over the property?
Registered sale deed in
Yes,
favor of
it's
Sonia
registered.
Kakkar has to be looked into so far area is concerned. सिर्फ 2.5 डेसिमल लैंड है, 1025 स्क्वायर फीट
का
आता
बात
है,
नहीं है।
तो 24
आपको एक बात बताइए, एक का 2.5 डेसिमल है, एक का 21.5 डेसिमल है, whatever be the proportion. One can agree कि इस particular tenant का आप रेंट ले लीजिए, बाकी पोर्शन का हम रेंट ले लेंगे. It is quite possible.
That is nowhere written.
May not be written, but what I am saying, what I am drawing
That
your
may be the
attention
defense
is
might not be
that
there.
merely because 50-50 has been mentioned in Exhibit 3, that does not say that that will not change the registered deed in any manner.
No, that will not change the registered deed in the manner, but the manner in the which the registered sale deed that can be looked into through that 50-50 manner. This is my submission.
That's it. We will prepare a note on your submission.
Absolutely.
2-3 pages should be sufficient. Whatever contradictions you are drawing and whatever submission you are referring with respect to Exhibit 3, you should just put it there.
Mine.
आप बताइए आप कितना करेंगे?
मिलॉर्ड इंटायर देखेंगे रिकॉर्ड, लोअर कोर्ट ने जो फाइंडिंग किया है सही किया है, करेक्ट किया है, कहीं कोई गलत ट्रायल कोर्ट ने नहीं किया है. और जहाँ तक विद्वान मित्र हमारे भी बता रहे थे लीज के बारे में, बार बार लीज पर कर रहे हैं, तो क्या लीज पर टेनेंटशिप में अगर कोई दे दिया मकान तो उनका हो जाएगा क्या? कहीं लॉ बता दिखा दें हमको कि उनका हो जाएगा.
टेनेंट का नहीं बोलते.
ये लीज टेनेंटशिप का ही है मैम. ये जो सवाल उठा रहे हैं 50% मैं बता रहा हूँ. मेरे नट से में मतलब हाँ
इनका कहना ये है कि एक के पास 2 डिस्ट्रिक्ट,
यस
एक के पास 21. But when they enter into a lease deed
Yes.
jointly in favor of ICICI
yes
Bank,
yes ma'am,
they do not distribute the income in the proportion of their land.
yes.
What they do is they distribute the rent 50.
मिलोट
So
ने
therefore he wants to draw an inference from that it was a joint family property and merely because it was only a small portion was lying with one of them, that does not mean that the property is not to be divided 50.
yes
इनका ये कहना.
ये मिलोट कभी कभी देखते होंगे, हम लोग भी देखते हैं कहीं कहीं, जैसे हमारा जमीन अगर हाईवे पर है, हाईवे पर देखते हो 21 आगे में है, आगे फ्रंट है, जस्ट सेट में मेरा है, तो आप देखते होंगे 10 गुना 100 गुना ज्यादा रेट में बिकता है व्यवहारिकता में जो होता है. तो ऐसा भी होता है, वो अलग एस्पेक्ट है. हमारा मैम है एक ही ये है कि जो ट्रायल कोर्ट ने किया है सही कंक्लूजन किया. दूसरी बात ये कि इन्होंने डिफेंडेंट नंबर 2 जिनके नाम से डीड है उनका गवाही नहीं हुआ, जो मेन पार्टी है उनका गवाही नहीं, सॉरी प्लेंटिफ नंबर 2 जो दावा कर रहे हैं 2.5 इसमें मेरा जमीन है, उनका हुआ ही नहीं. दूसरा बात है ज्वाइंट के बारे में 4 भाई बहन है, आया है एविडेंस में, इनको 4
आपने तो नॉन जॉइंडर का कोई भी नहीं किया.
नहीं ठीक है, मैं नहीं लिया उसका बात नहीं, ये तो अपने इनका इनको करना था मैम ना, ये पार्टीशन सूट लाया है, इन्होंने लाया है, इनका ओनस इन पर है, हमारे पर ये ओनस नहीं है, इनको था। ये तो मैंने पूछ लिया सवाल उनसे वहाँ कि और है कि नहीं डिस्क्लोज करने के लिए, अगर लाएंगे तो इनका ये फॉल्स किए ना मैम, इनको लाना था सबको अगर ट्रूली आए थे तो सबको पार्टी बनाना था, अगर ज्वाइंट ये मानते हैं तो। और इनका कहीं भी एक भी गवाहों ने नहीं सब इस केस को सपोर्ट नहीं किया, इंटायर पूरा आप देखेंगे कि जो मैम देख लिए सब कहीं भी। और जहां तक बात है, कभी भी गोतनी का प्रॉपर्टी का बंटवारा हुआ है क्या? हम तो आज तक नहीं सुने, हम अपने आप से क्वेश्चन करते हैं कि गोतनी के प्रॉपर्टी का बंटवारा, यहाँ गोतनी के प्रॉपर्टी का बंटवारा कौन आ रहा? भाई करवाने आ रहा। संजय कक्कर भाई हैं, विवेक कक्कर भाई हैं, और वो दोनों गोतनी हैं, उस दोनों गोतनी का संजय कक्कर आ रहे हैं बंटवारा करवाने के लिए। तो मिलोट क्या कहा जाएगा इसको? जस्ट हरास करने के लिए, इसलिए कि हमारी 2 बेटियां हैं और ये हमारे प्रॉपर्टी को हड़पना चाहते हैं किसी तरह से, यहां से वहां छल प्रपंच करके, कभी यहां से कभी वहां से करके, कभी यहां लाके कभी वहां फंसा के, बस इनका ही, बस पूरे इंटायर का बस एक ही मोटो है, हमको परेशान तंग तबाह करना। नहीं तो इंटायर में हम देखेंगे हमको क्या पार्टी बनाने के, हमको क्या था, इनको डिफेंडर नंबर 1 हमको बनाए, हमारा कहाँ रोल है इसमें? न मेरा जमीन है मैम, न मेरा कहीं कुछ है, उसमें भी वो पार्टी प्लेटिव 1 बने हैं, वो भी उनका जमीन नहीं है अपना, अपने बोले कि अपना अपना इनकम से है, अपना अपना स्वतंत्र है, और फ्रॉम बिगिनिंग से अलग अलग है, दोनों का इनकम अलग अलग है, कहीं कोई इंटायर कहीं ये कनेक्ट ही नहीं हो रहा है मैम ज्वाइंटनेस का। अगर फादर हमारे अगर खरीदते मैम, तो अगर बेटा लोग को बंटवा के तो आधा दे देते हैं मैम। मिलोड कोई बाप देगा, मिलोड किसी को 2.5 डिसमिल देगा, किसी को इतना बोलेगा ले लो।
स्टोरी फिलॉसफी तो हम लोग नहीं सुन रहे हैं यहाँ पर।
नहीं मिलोड, मतलब ये विद्वान मित्र हमारे बोले उस पर मैं बोला, लीगल वे में ये है मैम कि कहीं भी इंटायर एक भी ऐसा एविडेंस नहीं आया है पूरे कि जिसमें ज्वाइंट
एग्जिबिट 3 का कॉपी है?
हाँ
दिखाइए,
है।
क्योंकि ये बिल्कुल पढ़ा नहीं।
सर्टिफाइड कॉपी है मैंने देखा, अच्छा
वो भी नहीं पढ़ा रहा है ना?
सेम उसी का निकला हुआ था।
ये हाईकोर्ट से निकाले हैं?
नहीं मैम, ये लोअर कोर्ट से निकाला।
ये जो इस तरह से दिया है तो पढ़ा ही नहीं रहा।
देखते मैं पार्टी से पूछते हैं, कॉपी अपना है। नहीं
और एक बार इसको देखा जाए।
My lord will see the expanded formula.
ऐसे में मिलोड उतना रिलेवेंसी इस डीड का नहीं है जो लीज डीड की बात कर रहे हैं। ये केवल बस ये कर रहे हैं कि 50% मिल रहा है हम लोग को, इसीलिए मेरा ज्वाइंट है।
एजेंट तो बोल रहे हैं कि डिस्क्रिप्शन और प्रॉपर्टी दोनों तो सही है इसमें। उसमें ट्रायल कोर्ट ने कुछ एरर लिख दिया है इसमें। ये बोल रहे हैं कि एरर ऑफ रिकॉर्ड है।
ये कह रहे हैं कि उसमें प्लॉट नंबर जो मैम है वो एरर उनका रजिस्टर्ड जो हुआ है वहाँ पर एरर हुआ है, इसमें कहीं दो है नहीं है। जो रजिस्ट्री हुआ रजिस्ट्री होता है नहीं मैम, तो उसमें छूट जाता है करना, उसमें एरर है। यहाँ कोई एरर नहीं है, उसी का प्ले है।
नहीं तो इसमें अगर रजिस्ट्री डॉक्यूमेंट में
शेड्यूल में दिया हुआ है, शेड्यूल में
शेड्यूल ही तो है ना,
शेड्यूल में दिया हुआ है दोनों का।
शेड्यूल में ये क्या एरर दिखाना चाह रहे हैं, थोड़ा सा हमको समझाइए क्या दिखाना चाह रहे हैं।
क्या बोले
But schedule 1 जो है सेकंड सेट ऑफ फ्लैट का जो डिस्क्रिप्शन है विद डिस्ट्रिक्ट बोकारो, उसमें एक्चुअली खाता नंबर 84 प्लॉट नंबर 7217 में प्लेंटिफ और डिफेंडेंट दोनों का है,
ठीक
है ना। डिफेंडेंट का 7.5 डेसिमल्स है 721 में 17 में, और प्लेंटिफ का 2.5। सो जो 2.5 एरिया जो है वो सेकंड पैराग्राफ में है।
हाँ यस।
Whereas in the trial court judgment, trial court, वो कहते हैं कि इनका प्लॉट उसमें नहीं है। Even from the perusal of exhibit 3, the description of the scheduled property mentioned is खाता number 84, plot number 7217, area 7.5 decimals, and खाता number 177 जो कि मेरा नहीं है, plot number 7208, area 10.75 decimals, and plot number 7209, area 3.5 decimals, total area 20.5 decimals. Actually, it's 24 decimals altogether. तो उसमें मेरा प्लॉट का रेफरेंस नहीं है। The court has not considered that exhibit 3 contains plot of plaintiff number 2 also. That is that argument I am advancing. The findings, such finding is at page 20 of the last one paragraph. हाँ वही बोला, डॉक्यूमेंट में है, कोर्ट ने इसमें एरर ऑफ रिकॉर्डिंग, ये मेरा
ऐसे भी मैम इसका कोई रिलेवेंसी वैसा नहीं है। ये इस पूरे ये हम लोग पार्टीशन सूट में आए हैं और ये लीज हुआ टेनेंटशिप का। अगर अथवा तरीके के लिए सही भी है माने ये बोल रहे हैं तो 50-50, तो ये तो हमारा आपस का अरेंजमेंट है। एक ही जगह दोनों एडजस्टमेंट, दोनों जमीन अगल बगल में मेरा है, तो वो हमारा उसको पार्टीशन सूट से मैं लौट क्या लेना देना है। पार्टीशन सूट इंटायर अलग है, वो लीज इंटायर अलग है, दोनों का अलग अलग लेग है, अलग अलग है, कोई मतलब ही नहीं एक दूसरे का रिलेटेड को रिलेटेड। विद्वान मित्र हमारे को रिलेटेड कर रहे हैं, कुछ इनके पास है नहीं, तो एक लकुना के लिए उनको उसमें जोड़ रहे हैं, कनेक्ट कर रहे हैं उसको। मिलोट कहीं का उससे कोई लेना देना नहीं है इस पूरे पार्टीशन सूट से। और हमारा जो ट्रायल कोर्ट ने कंक्लूड किया है, करेक्ट किया है, कहीं कोई एरर उसमें नहीं है, कोई लीगल एरर नहीं है।
लिखाना शुरू करते
जी।
हैं। आज तो नहीं कंप्लीट होगा, कल लिखाएंगे। आप अपना नोट भी ले जाएंगे, आपका कोई सबमिशन छूटना नहीं आपका।
बस एक रेस्पॉन्स दे देना चाह रहे थे
हाँ।
अरेंजमेंट के लाइन पे। बस अरेंजमेंट हो सकता है, माय लॉर्ड वाज आल्सो ऑफ द करेक्ट व्यू कि फर्स्ट फ्लोर सेकंड फ्लोर में भी एडजस्टमेंट हो सकता है, बट वो तब होगा व्हेन रिटन स्टेटमेंट में ऐसा स्टेटमेंट्स नहीं होगा कि द एंटायर प्रॉपर्टी मेरा है, बिल्डिंग पूरी मेरी है, गवाही में बोला गया कि ये बिल्डिंग मेरे प्लॉट के ऊपर बना हुआ है, तब ऐसा अरेंजमेंट नहीं पॉसिबल है। Had it been the case कि अदर प्रॉपर्टीज में सब कुछ ठीक रहता एंड रिटर्न स्टेटमेंट में ये बात आता, आई मे नॉट हैव एनी पॉइंट टू आर्ग्यू ऑन दैट। तो वही बोला कि ये अरेंजमेंट गिवन द फैक्ट्स एंड सर्कमस्टांसेस ऑफ द केस डज नॉट सेट इन प्रॉपर्ली। दैट इज प्रॉब्लम व्हिच आई विल वांट टू रिस्पॉन्ड।
मिलोड हम लोग पार्टिशन सूट में आए हैं या लीज का ये में आए हैं? और गोत्री से कहीं होगा क्या बंटवारा? बता दें हमको, गोत्री से कहीं बंटवारा होगा तब तो डेली मैम हम लोग घरे में शुरू हो जाएगा कल से। हम तो पहली बार सुन रहे हैं कि विवाद मित्र हमारा गोत्री से बंटवारा करवा रहे हैं। मैम इसमें रिटर्न नोट्स हमने भी फाइल कर दिया है।
कर दिया?
जी
कहाँ है?
पहले फाइल किया।
फाइल की?
हाँ, फाइल किया।
ये
मेरे पास कॉपी है, देख लीजिए, मिला लीजिए कॉपी में।
काउंटर
आईने का काउंटर
आइए का काम
जी जी जी।
बोल रहे हैं।
हाँ।
This appeal has been filed against the judgment and decree dated 28/6/2024, within bracket decree signed on 5/7/2024, passed in original within bracket partition bracket close suit number 58 of 2022 by learned civil judge within bracket senior division bracket close 1 Bokaro, whereby the suit filed by the plaintiffs has been dismissed on contest. One IU number 14011 of 25 has been filed under Order 41 Rule 27 within bracket 1AA and Rule 28 of the Code of Civil Procedure, seeking to adduce additional evidence which is registered listing number 1545, executed on 21/3/2025, and registered on 16/4/2024. which has been jointly entered between the plaintiff between the plaintiff number 2 and defendant number 2 on one part and ICICI Bank Limited on the other part. By stating that this lease deed has been executed after the disposal of the suit and is a subsequent event. However, it is not in dispute that the document which is sought to be brought by way of additional evidence is renewal.
Yes.
Renewal of the same lease deed amongst the same parties which was marked Exhibit 3 before the learned trial court. And this has been entered into amongst the parties to the lease deed since the period of lease had expired in the year 2025. It is further not in dispute, even from the side of the respondents, who were the defendants in the suit, that the lease deed has been executed during the pendency of the case, but he has submitted that the same has no relevance and bearing in the present case.
What we find on schedule 1 to this leaves, it's the same set of page 35.
Yes,
Running page 35.
we can take it from there. During the course of hearing, it is not in dispute that except for renewal and change of rent also,
Yes,
Yes.
and
There is
change
no-
of rent,
yes.
there is no other difference when the additional evidence is compared with that of exhibit. After hearing the learned counsel for the parties on the interlocutory application seeking to adduce additional evidence, this court is of the view that the additional evidence ought to be introduced is merely a continuation of the relationship of lease amongst plaintiff number 2 and defendant number 2 on one part and ICICI Bank on the other. And the earlier lease deed having same terms and conditions being already on record as exhibit 3 and the suit is a partition suit. In such circumstances, there is no point. And this court is of the view that the additional evidence brought on record has no relevance in the present case. Accordingly, IA number 104-14011 of 2025 seeking to adduce additional evidence is hereby rejected. The case will be decided on the basis of materials already available on record.
But yeah, in view of exhibit 3, it has no relevance. It is
I
already-
said so.
ठीक.
I said
DP
so.
always.
It is already there, it is a
yes,
continuation.
Yes,
It's a
continuous.
clear relevance.
Yes.
It is further important to note that exhibit 3 is an admitted document. Right?
Great.
Original partition suit number 58 of 2022 was filed by Sanjay Kakkar, son of Kamal Kumar Kakkar, and his wife Sonia Kakkar. And defendants are Vivek Kakkar, son of Kamal Kumar Kakkar, and his wife Binni Kakkar. The suit was filed seeking preliminary decree for partition of half share of the plaintiffs over the land and the suit property mentioned in Schedule A of the plaintiff. And thereafter by appointing a survey knowing either commissioner or Amin to prepare separate takta of the share of the plaintiffs and for preparation of a final decree thereafter. The Schedule A of the plaintiff is quoted as under. The case of the plaintiff, as per the plaintiffs, that the plaintiff number 1, that the plaintiff number 1 and defendant number 1 and their father used to do a business in the name of Ispat Scooter. And the plaintiff number 1 and defendant number 1 were the case of the plaintiff's case that the father of the plaintiff number 1 and the father of defendant number 1 used to do a business in the name of Ispat Scooter, in which the plaintiff number 1 and defendant number 1 were also managing the business with their father, and they lived together from the joint fund derived from the income of the business of the father of plaintiff number 1 and defendant number 1. They decided to purchase the land from the income of the business, to which both the brothers also agreed. It is their further case that the father of the plaintiff number 1 and defendant number 1 had purchased the land and area 2.5 decimal of khata number 84, plot number 7217 in the name of plaintiff number 2, while registered sale deed number 6557 dated 20.12.2023. And since the date of purchase, the plaintiffs, the dependents and their parents remained in possession of the property. Thereafter, there was another purchase of land in the said khata number 84, plot number 7217, area 7/1/4 decimal, comma, khata number 177, plot number 7208, area 10.75 decimal, and khata number 177, plot number 7209, area 3.5 decimal, total area 21.5 decimal, by way of registered sale deed number 375 dated 30/12/2003 in the name of dependent number 2. And since the date of purchase, the plaintiffs and dependents along with their parents came in joint possession of this property,
The deed
of the state property.
number, deed number is 373.
आपके deed आपके plaintiff में 375
हाँ मैम, एंड ट्रायल कोर्ट के जजमेंट में भी एक दो जगह 375 भी लिखा हुआ है, 373 भी लिखा हुआ है.
तो आपके plaintiff में जो लिखा हुआ है वही देखेंगे तो फिलहाल
सेल डीड से बस हम एग्जिबिट 2 इज 373, हम देख लेंगे उसको.
ठीक है, लेकिन प्लेट में आपका 375 है. At this stage, the learned counsel, at this stage of dictation, the learned counsel for the appellant has stated that the sale deed dated 30/12/2003 has been exhibited as exhibit 2, but the deed number is 373 and not 375, and there is a typographical error in the plate. इसमें तो आपको कोई dispute नहीं? The learned counsel for the respondent has no dispute so far as this aspect of the matter is concerned. It was further case of the plaintiffs that before purchase of the land, the vendor had executed an agreement in favor of the plaintiff number 1 on 9/7/2003. And at the time of agreement, the plaintiff number 1 had paid the entire consideration amount to the vendors of the sale deed by way of bank drafts and other modes. And thereafter, the sale deed was executed in favor of in favor of the plaintiff number 2. And defendant number 2. So your case is the entire consideration amount was paid. It has also been asserted in the plaint that the entire consideration amount was paid with respect to the entire suit property by plaintiff number 1 with the consent of his father, from the joint fund of income of business of Ispat, Scooter and other. And therefore, the plaintiffs claimed that the property is a joint property of the parties. And they have been coming to possession over the suit property according to their convenience. However, there has never been partition by Nixon. The paragraph 3 of the claim reveals that it is plaintiff number 1 who claimed to have paid the entire consideration amount with respect to the properties standing in the name of plaintiff number 2 and also the properties standing in the name of defendant number 2. And for this, a reference has been made to an agreement of sale dated 9/7/2010. And upon query of this court, it is not in dispute that the agreement has not been exhibited before the court. It is further case of the plaintiff that the father of the plaintiff, number 1, constructed 3 stories house on the purchased land which constitutes the suit land, and some part of the suit land I don't get the meaning of this paragraph 4.
Just after purchasing of this land, the father of the plaintiff constructed 3-story houses on the purchased land. The suit land, some part of the suit land from the income from the business, and rest land is vacate and used by both the parties. It is difficult to comprehend, but
It is not comprehensible at all.
yes,
Anyways, I'll just write that he constructed 3 houses,
building 3-story building
3-story.
from the income from the business.
From the business end.
Business.
It was a further case that after construction of the building by the parties, they let out the second floor of the building to Messrs. Hotel Casablanca on monthly rent, and other building was let out to one Shriram Finance, ICICI Bank, etc. And
As per mutual consent.
and as per mutual consent, they obtained the rent of the said building according to their convenience. Not only that, the municipal taxes and other taxes relating to the suit land was also being paid by the plaintiff. However, during the course of argument, it is not in dispute that the arrangement made with other tenants over the building, like Shriram Finance, ICICI Bank, etc. Shriram Finance and other tenants on the building have not been brought on record. The only tenancy which has been brought on record is with ICICI Bank, which is with 3 in the present case. The plaintiffs claim that the suit property is joint property of the parties and they were in possession over the same according to their convenience, and as such there was complete unity of title, community of interest and unity of possession between the parties over the suit land. It was therefore the case that in the year 2017, the father died in the state of jointness, and after his death, the plaintiffs and the defendants inherited and succeeded over the entire suit property according to their convenience. However, at this stage, it is important to note that the plaintiff number 2 is the daughter-in-law. Plaintiff number 2 and the defendant number 2 are the daughter-in-laws. In the family. It was therefore the case that sometimes in the month of February 2022, both the parties decided to amicably partition the suit property, and thereafter a memorandum of partition was prepared according to their convenience, but later on defendants refused to make partition and claimed 21.5 decimal, which was the property purchased in the name of defendant number 2. A legal notice was also sent by defendant number 1 to the tenant of the plaintiff, namely Shriram Finance, through lawyer on 30/6/22. And thereafter, a panchayati was held between both the parties, sometimes in second week of July 2022. And in the same panchayati, defendant number 1 agreed to make partition of the suit land, but after lapse of 2 months, the defendants did not get it partitioned, and lastly on 30/9/2022, they flatly refused to make partition of the suit property by meets and bounds, and hence the plaintiff was compelled to file the suit. The case of the plaintiffs is that the defendants have no right to claim land or house situated in the area of 2.50 decimal, as the entire property was purchased by the father from income earned from the business of Ispat scooter, and the plaintiffs have got every right of half share over the suit properties.
It's 21.50 decimal.
Sorry?
21.50 decimal.
21.50.
It has been dictated as 2.50.
21.50. Thus, the plaintiff claimed that since the suit property was acquired from joint property, from joint fund, and income derived from Ispat scooter, which was being run by the father of the plaintiff number 1 and defendant number 1. And even the multi-storied building on the same was constructed from the same business income. Therefore, the property was joint and was liable to be partitioned half and half. Thus, the plaintiffs who are the son and daughter-in-law of Kamal Kumar Kakkar, the father, are claiming half share of the property. And they claim that half share would be of the defendant number 1 and defendant number 2, who are also son and daughter-in-law of Kamal Kumar. The defendants filed their written statement and alleged that the plaintiffs have that there was no question of partition with respect to the suit property, and material facts have been suppressed. The suit property has been purchased by the defendants from their own income, and therefore there was no question of partition, and there was no substantial evidence regarding the purchase of the suit property from joint income. A plea was also raised that the suit was liable to be dismissed on account of non-joinder and misjoinder of necessary parties. It was asserted that the suit property was not a joint property, and the property was not purchased from joint income of the plaintiffs and the defendant. And the defendants had purchased the suit property from their own hard-earned income, and there was no question arises for partition. It was also asserted that there was no iota of evidence to substantiate the fact mentioned in the plate with respect to the property being joint family property. The entire contention regarding payment of consideration amount was false and hypothetical, and the plaintiff has not filed any document regarding the payment of any consideration amount to the vendor of the CD by way of any demand draft. It was also denied that the multi-story building was constructed from joint family income, and the plaintiffs had not filed any bit of document to substantiate the contention. It was asserted that the defendants were landlord and they were bona fide purchasers of the property, and they have constructed the multi-story building from their own income and let out shop to this effect only, and let out shop to this effect only agreement with ICICI Bank had been prepared by the defendants. asserted that there was no unity of title, community of interest, and unity of possession over the suit land, and there was no documentary evidence to substantiate the same. It was also asserted that there was no cause of action, and the question of it was also stated that the plaintiff number one and the defendant number one were never in a state of jointness, and therefore no question arises for inheritance by virtue of jointness of properties. And there is no question of any partition. It was also asserted that in paragraph 15 of the written statement that the true fact was that no memorandum of partition was prepared according to convenience, and being a landlord of the tenanted premises, the defendant number one sent a legal notice through his lawyer It was also asserted in paragraph 16 of the written statement that the entire property was purchased by the defendant from his own income, and it was submitted that the plaintiff mentioned in the plea that the Ispat Scooter is a partnership firm, and being a partner, the answering defendant purchased the suit premises, and this manner the plaintiff has no right, title and interest over the suit property. प्लेट पे कहाँ बोले पार्टनरशिप फॉर्म? पार्टनरशिप फॉर्म तो नहीं बोले हैं प्लेट
में बोले कि इस्पात स्कूटर्स बिजनेस फॉर्म
हाँ बिजनेस
फॉर्म
पार्टनरशिप फॉर्म का ही नहीं बोले हैं, but this reference is coming to a partnership firm. It was also asserted that the properties not being purchased from joint fund and income business of Ispat Scooter, and being a partnership firm, all the partners have equal share distributed from the income of the business. So no question arises for that the properties is a joint property from the income of the business of Ispat Scooter. The written statement reveals that the defendants prayed that the suit be dismissed. एविडेंस तो हम दिखाएं हैं किसका किसका क्या क्या आया है.
जी
The plaintiff has adduced altogether 3 witnesses. PW3 is the plaintiff number 1 himself. PW1 is Ramakant Prasad, who Ramakant Prasad, and PW3 is
Mihir Kumar Singh.
PW2 is Mihir Kumar Singh, who is the friend of
Plaintiff number 1.
plaintiff number 1. Only 3 documentary evidences have been adduced on behalf of the plaintiffs. Exhibit 1 is the sale deed in the name of plaintiff number 2. Exhibit 2 is the sale deed in the name of defendant number 2. Exhibit 3 is the lease deed dated
11/8/2016.
11/8/2016, executed by plaintiff number 2 and defendant number 2 in favor of ICICI Bank, which is a registered company. So far as the dependents are concerned, 2 witnesses has been examined. DW1 is the dependent number 1, DW2 is the dependent number 2, and DW3, and no documentary evidence has been adduced on behalf of the dependents. The learned trial court framed the following issues for consideration. सारे issue आपके against है decide?
My place.
It has been submitted that all the issues, limitation वगैरह भी, waiver, estoppel, acquiescence.
The suit is not maintainable. First one is against us.
Okay.
The suit is properly valued.
Property value तो ठीक ही होगा ना?
हाँ. Valid cause of action में बोलते हैं कि नहीं है proposal.
अच्छा ठीक. The learned trial court held that the suit was not maintainable. There was no valid cause of action to file the suit. The plaintiffs was not entitled to half share in the suit property, and there was no unity of title and possession amongst the parties to the scheduled property, and consequently the plaintiff is not entitled to any claim
Yes.
as prayed for in the plaint, and ultimately the suit was dismissed. Okay? As the court time is over, post this case for further detention tomorrow. It will be very nice if you could आप अपना argument थोड़ा concise में डाल देंगे. 2 पन्ना should be sufficient. 2-3 pages. आप भी थोड़ा सा आप तो डाल दिए हैं.
हम डाल दिए
कल लिखाएंगे. अब यहाँ तक तो फाउंडेशन तो
यस
कल पॉइंट फॉर डिटर्मिनेशन लिखाएंगे और फाइनल्स.
कल वी आर प्रेजेंट
सॉरी, आपकी मर्जी है, आप ऑनलाइन भी ज्वाइन कर सकते हैं, कोई ऐसा रिक्वायरमेंट नहीं है.
ठीक
ऑनलाइन इज गुड